Yo, what's going on, guys? Oh, you've got no sound, Nick. Oh, so you guys can hear me, but not Nick, right? Oh, wait, Nick's that way. So you can hear me. Well, that means it's on Nick's side, which means really, honestly, it's the inferiority of Northern technology. Southern technology, particularly Korean technology, very advanced, very advanced. But anything when you get a nose that size, it really starts to interfere with the audio. What's going on, guys? Good to hear you. Welcome to Andrew Cada Law. Yes. I looked at in the Captain Phillips voice. I'm the captain now. North Korea is Beth Korea. Get out of here, Ken. Get out of here, Ken. Troll in the chat already. Welcome to my new OnlyFans channel. This is
okay.
Content.
I think this is getting better.
Good stuff. Yeah.
Okay. I can't hear you still. I'm working on that.
Everybody in the chat hears me, so
I can't hear you at all.
Oh, okay.
Just a second.
Well,
my life is a disaster. Everything got screwed up.
Oh, wait, I'm in Korea.
Where are you?
Well, we're somewhere. I know. I always have to carry for Nick, F in the chat. Although, guys, if you didn't see it the other day, I had a total boomer moment that was pretty epic.
I might have to change. Wait, is this it?
What? Can you hear me now?
Nope, this isn't it either.
Oh man, this is worse. That one time I tried to make a call.
I got an idea.
In 7th grade.
I can fix this.
No, he can't. It's never gonna be fixed, guys.
I can fix this. I can.
No.
Believe it or not.
Okay, so what story do you guys want to hear? You want me to tell you a story? What type of story do you guys want to hear? Do you want to hear a funny story? Do you want to hear a law story? Do you want to hear a story about this one time in law school when I ended up on a bus full of law students and catching a girl's vomit in a baseball cap? I mean, what are we talking about here? What type of story do you guys want? Okay, funny. Oh yeah, I got a haircut today, so I'm looking a little bit more federal, a little bit more glowy, if you will.
This is absolutely insane. I hate it. Oh, there we are.
There you got it? You got it?
I've got it for now. Okay, I've got it enough.
Okay. I only half took over your channel, Nick. It's okay.
No, it's fine. You deserved all of it. You deserved the whole channel. So what happened was I have this new, much more complicated audio setup, and I forgot I have to save everything. And my computer got force rebooted. So right now everything is wrong. Like I'm really quiet.
It's all wrong.
So I'm going to turn. Literally everything is screwed up. That's better. Oh my gosh.
Oh God, man.
So anyway, I'll have to play around. I think I did save it, but I'll get it loaded up. I wasn't prepared for this live stream to start.
I didn't even know this was happening. Frankly, honestly, I covered the arraignment of the parents, and I would have thought that Crumbley was already arraigned. So this is actually kind of a surprise for me. I was just up doing work, and this is pretty interesting to me.
Yeah, it was a surprise for me too. Someone's like, "Why aren't you covering this?" And then I looked it up, and it's like, "Oh, it starts at 2." Well, I assumed 2 Central, but it's Michigan, which I think Michigan is in Eastern time.
I'm not sure what they are.
So they have started, but I have it paused right at the beginning, and so we can cover everything. Right before we get fully started, I am gonna do they're the super chats that came in right as the show is getting started. I want to get those.
That's right.
And then we'll go. Okay, Billy Witch Doctor says, when do you think we'll get that Supreme Court ruling? Also muted boomer. Yeah, I know. I'm so pissed about the audio.
Well, one thing I will say about that one, Nick, and I haven't heard your comments on it. So we didn't get a stay. I haven't seen a stay yet. So
No.
It's in effect then.
It's in effect. The rumors from SCOTUS blog is that there are some quote unquote rulings coming out on Thursday, tomorrow. So the reason I don't think that they were too urgent with the stay is because the actual vaccine mandate part of it doesn't kick in until like the end of February. So there was still a little buffer time, even for people to get their first shots followed by their seconds. There's a minor amount of buffer time in theory. In practicality, a lot of the businesses just said, no, you have to be vaccinated by 2 days ago.
Well, a lot of the businesses were requiring it, frankly, months ago, and trying to push similar provisions even earlier than this. So, just because the mandate is here doesn't mean your employer might not be. And frankly, Nick, over the last couple of days, I've had more people reaching out to me for the exemption letters, which I have posted on my locals. More people have asked about that than ever before. So it seems like, regardless, employers are pushing it.
Oh yeah. And that's what I was saying to people is like the mandate at this point, it doesn't matter. The government accomplished its goal. The employers accomplished their goals. Because you are corporate counsel or at least, So I assume you can back me up on this. They were begging for the government to mandate stuff so that they didn't have to worry about it. So they had someone to blame.
Not only that, but they're begging for a federal mandate. They're pretty much begging for a federal mandate because they were tired of having to deal with, and frankly, one of the things I was doing last year was I was going through a 50-state analysis daily in terms of regulations and restrictions on national corporations. I can't make this shit up. And just the infuriatingness of it was one of the reasons why I just went all in on my YouTube channel, because I'm like, this is ridiculous. You have Hawaii, which thinks they're pretty much the CCP, and then you've got Florida, which is like, fuck it, YOLO, just do what you want. It's two different Americas, completely different Americas.
Logan Orr says this audio is gayer than Binger. That's true. That's true. I have to refigure out how to do everything that I did, so that'll be great. Q Revere says the most ruthless chat on YouTube. That's true. New dislike button says he licked his mic last night and his mic said, all right, I'm head out. Quicks DC 614 says, is it plugged in? Yes, it was plugged in. The problem was I didn't have my audio plugins running. Bilbonius Bag of Donuts says, did Jack Murphy get familiar with your mic? Is it damp?
Oh my God.
Smells weird.
People have sent me too many of the videos behind the scenes, by the way, Nick. I blame you entirely.
Dude, I did not want to see all of that wiener.
I've seen hooks and devices and all sorts of things. It's I can't.
Yep. Quick says, let me LM help grandpa fix computer. Gates of Above says, Nick, I can fix this. Chat. I doubt it. Here, let me help out with that, chat. Let me help out with that.
I doubt it.
Let's keep it on tap. Let's keep it on tap. It's great.
It's ready to go. It's ready to go.
Thank you, swing.
Okay. So I've got this thing loaded up. We're basically ready to go here. Let me share the screen and we'll get in on this. Here we go. Look at this ragtag cast of characters.
Jesus Christ. Sorry.
We've got the judge down here on the bottom right. We've got Ethan Crumbley up here, and we've got a whole cavalcade of weirdo attorneys and associates.
Squares.
Yeah. So I don't know who any of these people are. I'm sure we'll find out momentarily.
I know who some of them are. I think this lady down here in the center, she's the prosecutor for sure. But yeah,
that's why she's got the flags going there. Very, very cool. Darren Haviland says in a Richards voice, McDonald's forgot my fries. It's just like Pearl Harbor. Okay. Let's get this show on the road since we're behind. What? Is it over? What the hell happened?
Fudge.
What is this shit? Okay, I'll get it from that.
Man,
I'll get it from a different source. Just a second, dude. Can anything go right today?
No, they can't. No, it can't. Any good deed to, upgrade your quality for your audience must be punished, Nick, and must be punished severely. Also, your ability to stream MasterChef, that just is totally out the window on Twitch.
Exactly. Where the hell? What? Here we go. It's already over. Amazing. This will be short then.
That's fine. Yeah.
Why is my phone ringing? Leave me alone.
The one for the parents was actually decently long, but mostly because they had to deal with the potential conflict issue, and they had to do it one by one.
Dude, this is super short when we actually get to it. We're talking like
someone says Law and Crime streamed it.
Yeah, I've got it pulled up here. It's like 10 minutes or something, which is crazy town. Hold on, there's one other thing I have to do. Pardon me. I hate the beginning of January. The beginning of January has been a disaster for me. Like everything that I've worked throughout the past year to avoid having come up as an issue has come up. Stop.
So what other blights have you dealt with?
Oh, just like I have to. I got to a point where I wasn't having to drive my kids around all day, and like I've had to drive them around every day this year. It's like, so it's made daytime streaming really difficult. And I'm sure the chat is happy.
Once they get old enough to joyride on their own.
Yeah, please, God, get them. I was dreading my kid getting a car, but now I'm like, oh, can we get him approved at 14? Like, can I get one of those farm licenses?
Like a motorized razor scooter? Like, come on now.
I need to buy a farm so that my kid can get a farm driver's license. That's what I need.
Is that a real thing? I didn't know about that.
Yeah, they can get them like really like 14, I think.
And you can drive outside of the farm or just on the farm? Outside
of the farm. But I think they have to be in a farm related vehicle, like almost like a work driver's license or something.
So a tractor.
Well, or like a truck, right? Truck that just says farm on it. Okay.
Maybe Kiwi also?
Yeah, Kiwi farm. That's right.
Yeah,
yes.
yeah.
Just a humble Kiwi farmer.
Hey, bro.
Okay, here we go.
The Oakland County Circuit Court is now in session with the Honorable Kwame Rowe presiding.
Thank you. Good afternoon, everyone. Appearances for the record. When you give your appearance, please indicate whether or not you consent to proceed via Zoom this afternoon.
Karen McDonald on behalf of the people, and I consent to the Zoom hearing.
Thank you. Mark Heast on behalf of the people. We consent.
Good afternoon, Your Honor. Assistant Prosecutor Kelly Collins, appearing on behalf of the people, and I too consent to Zoom.
Good afternoon, Your Honor. Paulette Michelle Law on behalf of Mr. Crumbley. We are consenting to proceeding by Zoom.
What if they all just said, what if one of them just said, no, we don't consent, just to piss everybody off?
Then they have to come in, right? I mean,
yeah, that'd be great. I wish they would.
I mean, if anybody was going to be the Karen prosecutor, but she seems down.
Good afternoon, Your Honor. Amy Happ on behalf of Ethan Crumbley. I consent to Zoom as well.
Good afternoon, Your Honor. Deborah H. McKelvey, court-appointed guardian ad litem for Ethan Crumbley, and I have no objections to proceeding with this matter on Zoom this afternoon.
No objections.
Thank you. Good afternoon to all counsel. Good afternoon, Mr. Crumbley. Mr. Crumbley, can you hear me, sir?
Yes, sir.
You understand that you have a right to be present in court today. Are you okay with proceeding via Zoom just for the purposes of this arraignment?
Yes.
Thank you. Prior to calling this case, the court did have a brief breakout room with the attorneys. I did discuss the issue of any potential conflict. As all attorneys on the call are aware, I was a former assistant prosecuting attorney at the Oakland County Prosecutor's Office. Upon talking to counsel, I do not believe there's going to be any conflict with me presiding over this case. Is that correct, Ms. Lofton?
That is correct.
Okay. Any objection from any attorney on the case of me presiding over it?
Not from the people, Judge.
No, Your Honor.
Thank you. And with that being said, the court is comfortable with proceeding in this matter, and I don't believe there to be a conflict in this case. Today's date and time set for an arraignment. Ms. Lofton?
Yes, Your Honor. I would waive the formal reading, stand my client mute, ask that a not guilty plea be entered.
Thank you. The court will accept jurisdiction, enter a not guilty plea on behalf of your client.
Okay, real quick. So, what happens at a first appearance or an arraignment is the court will go ahead and read into the record the formal charges against the defendant. That is a right of the defendant to have the formal charges read into the record. In this case, there are 24 felony charges. There are 12 charges, the various murders and so on, and then 12 charges of committing a felony with a gun involved, which is a separate charge in and of itself. They have waived that right, so they're gonna save a whole lot of time, because reading 24 charges into the record is kind of like going to Bonanza and waiting for them to bring fresh food out. It's just never it never gets done. It never gets done. The mashed potatoes have crust on them by the time the green beans come out. So disgusting. Here we go.
It's my understanding that according to the Juvenile Justice and Delinquency Prevention Act, that a hearing must be held before January 21st of 2022 regarding the placement of the defendant. However, because of the pandemic, we cannot effectuate an in-person hearing, which I believe it would be appropriate in this case because of the high number of COVID cases, a positivity rate in Oakland County. Because the number of COVID cases are so high at this time, the court is finding good cause to extend those 30 days because we cannot effectuate an in-person hearing at this time due to the positivity rates. It's my understanding that defense is requesting in person, and I believe that is absolutely appropriate in this matter. And so what I am going to require the attorneys to do is to submit briefs on this issue. Briefs are to be submitted on the issue of placement on or before January 19th, 2022 by 2 p.m. And we will also have a status conference on January 19th, 2022 at 2 p.m. And that status conference is only with the attorneys. And the purpose of that status conference is just to set a new date for the hearing under the Juvenile Justice and Delinquency Prevention Act. And I will note, because of the high number of victims in this case, that this recording will be posted for 24 hours after today's date. The last issue I believe that we need to address is the issue of appointing LGAL. I did have an opportunity to speak to counsel. This court is reappointing Ms. Deborah McKelvey as LGAL for Mr. Crumbley throughout this matter.
That's a legal guardian ad litem.
Anything else from either party?
Yes, Judge, thank you. I just wanted to make sure that Ms. Lofton did acknowledge receipt of the general information.
Yes, I have the general information.
Thank you.
Thank you. Anything else from either party?
Not from the people. Thank you, Judge.
Nothing from defense, Your Honor.
Okay.
No, Your Honor, thank you.
Thank you very much. I will see you all on January 19th at 2 p.m. And again, that's only the attorneys. Mr. Crumbley, you will not be present for that hearing.
You're going to be in prison.
We're just setting that so we can set a new date. If there's nothing else, everyone is all set. Everyone have a great day.
Thank you very much, Your Honor.
Thank you.
Well.
Thank you.
You can stay cozy in jail.
Yeah, everybody have a good day, but you know.
Yeah. Don't worry about showing up. Don't worry. The deputy won't bring you over.
I'm just laughing. I'm like, you guys are still playing Pandemic up there? That's cute. That's cute.
Well, yeah, they're gonna play it forever. This is Michigan, man. That's Whitmer country.
Oh yeah. I mean, what are they gonna do? Kidnap her? Oh wait.
Oh, very spicy. Very spicy. So that's it, guys. It was a very basic hearing. As you saw, right? What? Oh my God. Hold on.
Yes, that was so basic that might as well have come with some avocado toast.
Yeah. and if you want to know, like, part of the reason why the criminal justice system is such an onerous pain in the ass, this is it. That was an appearance. That was that. So that was an hour of all of those attorneys' times. That was an hour of the judge's time. There's an hour of any assistants that may have been involved's time. If he's paying for, he's got a public defender, I assume. But if he's, or does he have a private defender?
I think she may be private. I have to double
How?
check.
Where do they have any money to run a private defense for?
I don't know. I have to check.
A dodeca homicide, a dodecicide case.
Oh God.
Just the 12 murders though.
A baker's dozen. Yeah.
But yeah, so that, despite the fact that the hearing was only about 10 minutes, you've got an hour of time for everybody involved, a bunch of money. And then the next hearing is going to be basically what could have been accomplished at this hearing. Like this, if you notice that this could have been done by email, just saying, by the way, your briefs are due on the 19th or whatever. That's true.
Yeah, and hey, we
could have
we
been.
have a required statutory hearing that we have to have, so attend it on this day. Is that cool with you? Oh, it's cool with me? Okay, good, cool. Let's do it.
Or four kills. Sorry, not 12. I was misinterpreting the charges, and forgetting the case. But yeah, four kills or whatever. That's so much better. That's what? That's 33% as bad.
Yeah, it's 400% as bad as January 6th, but we're not going to go there.
Oh, wait a minute now. Wait a minute now. Woo. That's the thought police are coming. Woo, woo, woo.
Sorry. The domestic terrorism. Now that we're both domestic terrorists, Nick.
Yes.
So,
yes.
For supporting anti-government thoughts. Yes. For me saying that the government should not be allowed to call themselves the people, because it's more clear that these prosecutors absolutely do not represent the people of these United States.
Right. So anyway, as for the hearings, I saw a question in chat that we should talk about maybe a little bit. They said, why would he plead not guilty? And the answer is, why not plead not guilty? That's the answer. If he pleads guilty right now, he gets whatever sentence will come his way. And there's absolutely no benefit to doing that. It's likely that he faces life in prison without parole as a punishment for murdering 4 people. So there's no harm in going after some sort of victory, at least in the interim. You plead not guilty because there's no damage to your case to do so.
Mm-hmm.
And at this juncture, it doesn't benefit him to plead guilty, unless he just doesn't want to do anything. But if he doesn't want to do anything, he wouldn't have an attorney there. The attorney's job at this point is to either find some deficiency in the government's case, which is going to be hard when you murder children in a school. It's going to be hard to find a deficiency in the government's case on all of the charges. The other possibility is to work out a plea deal. And if you getting a plea agreement on paper, that would maybe see him in prison for 20 or 30 years as opposed to the rest of his life. When is he 15?
I do not know exactly. I know he's not. He's under 17. I know that. I think he may be 15.
Yeah, but either way, so let's say
15. Yeah.
Yeah, so he's either he's 15. I don't know when he turns 16, but if he can get out of this thing by spending 20 to 30 years in prison, he comes out in his 40s, and that's actually, there's worse things in the world that can happen to you.
And a lot of people are mentioning, and I saw people saying it earlier, not guilty based on insanity, right? Because that's a potential thing that gets brought up, but that's not much better. And one thing in Florida, talking to the prosecutors here, it's like, you're effectively stuck under treatment for life. So, that especially in this circumstance, we have a crime this heinous, you're getting as much time. So that's not really an out, so to say.
Yeah. Yeah. And plus he's going to have a hard time. So insanity as a defense is not what people think. Typically, anyone who kills someone is crazy in some way. They're acting in a way that does not conform with societal and social norms. So they're a little bit off, you would say, because they've murdered someone. Now, I'm not talking about someone like an accidental killing. I'm talking about premeditated homicide.
The voices in my head told me to do it.
Right. The question is not whether or not you're hearing voices and whether or not your behavior is aberrant from normal behavior. It is. You murdered someone. The question is whether you are able to consciously determine right from wrong. That's where insanity comes in, and where a lot of people go, but this guy's crazy. It's like, yeah, they're crazy, but they know that killing is wrong. and that's enough. If you know that the actions you're about to take, or not even if you technically know, but if you have the ability, the cognitive ability to know that something is right and wrong, then you are not insane under the legal definition most of the time. So it's a very complicated thing. That's why someone like Chris Chan is probably still competent to stand trial and still likely sane enough, because even though Chris Chan is a lunatic, the reality is that Chris Chan knows right from wrong on some level, even if the right from wrong happens within the dimensional merge.
Is that trial starting soon, Nick? Do we have a date on that trial? Because that is going to be.
I think it's in the
gold.
20s. I think it's in the 20s of this month.
Oh, nice. So that's like a week or two.
But I don't think it's going to be televised. I mean, I can't imagine.
No.
How would they do that?
Yeah.
So
yeah, it would definitely, the content would be too spicy for YouTube, I'm sure. That's
I would do it anyway. We would do that. Let's see. Let me pull up his
the information.
Yeah, so he's got I don't have the charging document, but I've got the summary of it. 1 count of terrorism causing death, 4 counts of first-degree murder, 7 counts of assault with intent to murder, 12 counts of possession of a firearm in the commission of a felony. So that's the 24 different charges. He is, I would assume he's being charged as an adult, but he's still entitled to the juvenile justice protections. And that's why he had a legal guardian ad litem with him. She is there to represent his interests. Remember that people under 18 lack the capacity to make legally binding decisions for themselves. So a guardian ad litem is there to act in that capacity in the absence of parents, and his parents are being charged in this case as well. And we have a guest to add to the stream here.
Ooh, nice.
What's up, Bronco?
Good to see you, brother.
Oh, just thought I'd join in. I don't think I've actually watched a U.S. arraignment before.
Well, you missed it.
Oh, did
it was like
it was over like that.
It was like 8 minutes long.
Fair enough.
Nothing happened.
As quick as a Trudeau mandate.
Yeah. So now we're just talking about. Let's see. We're talking about the charges, and I'm adding you guys to the description right now.
Thank you, sir. So I mean, I think that in terms of the Ethan Crumbley case, I think, most people, and probably the chat, most lawyers are like, yeah, the kid, he's guilty here. Like, there's going to be some guilt. The facts are not looking good for Ethan. Okay. But the parents, I think from a legal analysis standpoint and potential scope of liability in the future, potential expansion of liability for parents for the actions of their children, I think that's, from a legal standpoint, a purely legal standpoint, a little bit more interesting to me than following Ethan. That's just my 2.5 cents on this one. No,
from a legal standpoint, I agree with you fully, because the idea of charging parents for this type of crime is beyond what I think is appropriate. And the other thing, have you guys seen the new stuff about what the school knew? Came out like yesterday.
No, but they were really the ones who called the shots and sending him back into the room.
The school, you're saying?
Yes, the school counselor was the one that really made the call.
But it's worse than that. It's worse than that. So, like a week before this thing, he brought a bird's head in a jar full of yellow liquid, and put it on like the back of a toilet or something and left it there. He admitted to that. The day before doing this, he posted on some social media site, and the school knew, by the way, about this post. He said, "I am become death, destroyer of worlds. See you tomorrow." I know he's quoting Oppenheimer. He's quoting Oppenheimer, but he says, "See you tomorrow, Oxford." And this is in the context of him bringing ammunition to the school as well and being caught. All of this happened. The school was aware of all of it. Apparently, I don't know if they brought any of this up to the parents, but they were aware. So, like, the idea that the parents are responsible and that the school might not be is insane to me.
But Nick, was he wearing his mask at school? That's really what we want to be paying attention to here. Because if he wasn't wearing his mask, he would go home immediately.
Yes. Yes. How dare you? How dare you? Get out of here. You're very dangerous to the students without your
Bird
mask
head?
on.
Bird head, okay. Mask,
But yeah, so that's that's the stuff that's been coming out about what the school knew. And yet the prosecutor said if she thought that the school officials were as guilty as the parents, she would charge them. And they have much more evidence that the school is culpable in this case than the parents, in my opinion.
Let's charge them, man. That'll be fascinating. That will be fascinating if they charge the school administration and perhaps the counselor, whoever else. I mean, there's definitely some negligence there in a civil sense. I think in terms of civil liability, that is not looking good for the school right now.
Yeah. Someone's asking that was he remanded to custody? He was remanded to custody. I mean, he's been in custody the entire time. He wasn't leaving custody. This was not a bail hearing. This was an arraignment. And
he's not getting bail.
I think his odds of bail are probably pretty low.
You know what? You guys are bigots. I don't know why you would say that his odds of bail are really low. I mean,
it's because it's ageist, and he's also under 6'6".
What on earth would make you think that this person shouldn't have bail? I mean, I don't know. is discriminating much here? This is an upstanding and safe-looking young man.
Hey, now, I'm sure that haircut wasn't entirely his fault. Somebody had to let him walk out of the place and be like, no, that's fine.
Runkle, it's not the haircut that bothers me. It's the eyes that pierce the soul that bother me.
I feel like that's just being a teenager, but that's...
Yeah, I don't know about that.
Solid
that looks like a guy who, like, in middle school would have cut me for attacking him in Magic the Gathering with my Land of War Elves. Like that. I mean, like, literally, that guy looks like he has mental issues.
Yeah, let's see. Yeah, it looks like on December 13th. December 13th was when he had his first appearance for probable cause, and that's when they would keep him. So you get in the US, you get arrested, and then there's rules about when you have your first appearance. There are state rules, but they're also bound by some level of the Constitution. It's not entirely clear, and it's all done through case law. I think there's the main case law comes out of California on this stuff, but you're entitled to a probable cause hearing within, or your probable cause conference within 48 hours, not including Sundays. Saturdays are included, but not Sundays and not holidays. So you get your probable cause hearing within a reasonable time, but no longer than 48 hours, not including Saturday. It's a messy thing. And then you have a 36-hour hearing that you're also entitled to. They tend to wrap them into one, but if for some reason that 48-hour here, and that one is exclusive of Saturdays and Sundays and holidays, so it's a little bit more flexible. So it's funny because your 36-hour hearing can, at various times of the year, happen after your 48-hour hearing has happened. But typically they'll just do them both at the same time. But the 48-hour hearing must occur. So if it's on a Saturday and court's not in session, they'll do it by phone with a judge, and that's okay for the 48-hour. But you're going to get your 36-hour probably within the first half of the day on the Monday. Typically this falls on a weekend or a holiday issue. So
was the by the phone thing before the coup, or is that post coup?
That was before the coup here in Minnesota. Because what you got is, if you get arrested on Friday at 12:03 a.m., right? Your 48 hours runs Sunday at 12:03 a.m. They have to give you that hearing prior to that 48 hours. They're not gonna be able to keep you until Monday for that. So they have to do that on the Saturday or even on a Sunday morning. They'll call the judge. There's a judge on call for it, and they'll just run through them really quickly. And they have a big stack that's organized by time, so they get through them. But yeah, so that's just to determine if they have cause to hold you for your 36-hour hearing. Very, very great. And you're not entitled to appear at that hearing at all. Like you're not, all you get is a notice that it occurred, and a prosecutor reads a probable cause statement to a judge who's probably sitting there tubing, and then he just says, yeah, whatever, keep them. I don't care. They never let anyone go. On those things.
I mean,
gotta
what
love
would the
due process.
standard have to look like to get released on that? Because if it's just, do we have grounds to think an offense happened? It's like, well, we got a sworn statement or indictment or whatever.
There would probably have to be a lot of proof that it didn't happen. Like,
Yeah,
because probable cause is such a high threshold.
It would have to be the cops grabbed someone to get them out of a situation. They arrested them. They didn't have probable cause of a crime. They, upon investigation, found there was no probable cause, and then they just wanted to be dicks, so they held them for up to 48 hours, and that is rare that actually happens. It happens in the movies, right? Steven Seagal does it to people, and that's funny, but it's rare that they arrest somebody without any cause, because the amount of probable cause is just whatever the cop writes down on the paper, and you can contest it later. It does not take much. It's like, no, I thought he was loitering. He was hanging around.
I had reason to believe. That's it.
Yeah, it was. So it's a very, very low bar, but that's all it takes. Okay, let me read some of these chats here. Cass Arthur says, Nick, did you hear about the man who was evicted from a Ronald McDonald house in Vancouver? His 4.5-year-old son has leukemia, and they told him they had to leave because his son was not vaccinated. Yes, I've heard about that. Canada is cancer. It is. But so I guess all of Canada now needs to go to the Ronald McDonald house. That's what makes sense, right? So they can all be treated. No, it's appalling. There was a tweet. I hate that we can't talk too much about this, but there's a tweet from a doctor today who's fully vaccinated, frontline medical worker, but he tested positive for COVID. And he points out that under the CDC regulations, even though he is positive for COVID, because he's vaccinated, he can still show up to work. But whereas an unvaccinated person who is not positive for COVID cannot show up to work. That's how backwards things are right now, because the propaganda has been so strong that whatever the propaganda says, the people out there believe that vaccines prevent the spread entirely, that a vaccinated person cannot transmit the virus, which is not true. The vaccine doesn't.
Be fair,
right.
They've said that at certain points, Nick. They've said
yes.
that. And Biden said it. Kamala said it. Even I think at one point, it was intimated by Fauci without him saying it directly, because he's always very careful about what he says. But it was hinted at. It was suggested.
Yeah, and that's what I'm saying is, I know someone has said it.
Right.
That's where I was going. Someone has said it so well that one of the justices of the Supreme Court believes it to be true, even though that is not, and I'm not making statements about the effectiveness of this vaccine in any way. You got to talk to your doctor. All of the disclaimers for YouTube. I'm not a medical person. I'm saying the way that vaccines work, you can still be a carrier of a virus for some period of time. And it is possible to transmit. Now, there may be data on it reducing transmission or whatever, but in reality, we have this issue going on, and so it's crazy how backwards everything has gotten. Where you're in this leukemia ward, you've got an unvaccinated 4.5-year-old being evicted from the Ronald McDonald house, which is where, no, this is a place where they should be safer and better able to receive care and in a cleaner environment. And we don't even have a vaccine for 4.5-year-olds, do we? Isn't it? Is it I think the 5 to 12 one is it doesn't have its approval yet from FDA. The 12 plus one, I think, does, or has got an emergency approval or something. But I know there is a 5 to 12 vaccine, but it's not FDA approved yet. And this kid's under 5, so that's crazy. But of course, this is Canada, so the FDA of the US doesn't really matter there, I suppose.
Yeah, I'm not sure what their approval process looks like. What your approval process looks like, Ian. I think some of the craziness, and I know somebody in the chat mentioned it. I'm reviewing with my community the book "The Real Anthony Fauci" by Bobby Kennedy. And I'm going to do a local stream on that. But a lot of the stuff that's approved is not actually what people think is approved. Let's just put it that way. And part of the designation for EUA requires that there's no alternative treatments. So if you look into the alternative treatments, and I'll just say that because that's going to keep us clean, just alternative treatments, and what they got rid of before the EUAs were passed, things start coming together.
Well, it's the interesting thing is there are multiple vaccines. And do those qualify as alternative treatments under the EUA? Like, doesn't that, it's a weird area of law that hasn't really needed the level of testing. We haven't run into this issue before.
Well, we defer. And that's what I've been talking about on my channel is the issues that we give so much deference. And yes, there is a point at which we do have to question stuff if it's just science that is arbitrary and capricious. Just because the CDC says it doesn't automatically make it the science. It's now a meme
for the
because
purposes of legal analysis. I'm saying this for the YouTube reviewers who will undoubtedly review this. When we're talking about arbitrary and capricious, that is a legal standard that a government agency cannot just make something so by saying it is so, that there is a point in which we get to question beyond the deference. I forget the Supreme Court case. Chevron.
Chevron's deference.
Chevron deference. Chevron deference says that as long as the main procedures are followed in enacting something administratively, we give deference to the administrative agency's determinations about matters of fact in regards to legal definitions. And so, but that can be pierced. It's a deference. It's not an automatic, but it's a high burden to pierce that deference. So one of the ways you pierce it is arbitrary and capricious nature of it. You show that there's no data to back it up. We're not saying that that's happened here, but we're saying that that's the way in which you would approach something like this, where the agency has been given that deference.
Mm-hmm.
So,
in Canada, I think you just give them full deference, right, Ian? I mean, it's just whatever.
The Crown has said so.
It's tough in terms of like, this is not my area of law, and there's people always ask me like, hey, what about vaccines? And I'm like, this is like 12 different areas of law, some of which are really complicated, because it's like, if your employer is saying you got to get vaccinated, now you're in employment law. And out in Quebec, they're floating the idea of charging you $100 a month if you're not vaccinated. So they want to, impose serious financial penalties, they've said, which, is a bit of a big deal. So like that's an entirely different set of issues. And yeah, I'm always just like, I'm not a scientist. I don't know. So
well, and it's also so specific. It's very, very specific. And just like when I was corporate counsel, I had Canadian counsel in every single province, and also we had, our Mexican counsel, state counsels. But this is a very specific area of law. And when you're dealing with administrative approvals, that's even more specific.
Oh, for sure. And sometimes it'll come down to really specific, details. Somebody says, hey, can my employer make me get vaccinated? I have the following health conditions. And I'm like, this is a question that needs like 4 different experts to address your specific scenario. And like, here's some names that maybe might look at it. That's as best I can do. Because,
and that's what I've been trying to collect for, anybody who wants to message me, who is counsel, who's dealing with this, who knows about this, who's an expert in this. I've said, hey, send me your email. I'll keep those, because when people ask me, I always love having good names of people that I can say, hey, this is a person in your jurisdiction, because, I'm over here in Korea. I'm not representing you guys in America right now in active litigation. So,
he fled. He fled to the land of kimchi and K-pop. Disgusting.
Look, I've got a lot of debts. The Squid Games is my only option, guys.
But yeah, the funny thing though is every time I think about how much of a nightmare administrative law is in the United States and how much I hate it, I think, oh God, but I really wouldn't want to deal with the administrative state of like Mexico.
It's a nightmare. And on top of that, you layer the fact that you, frankly, in a lot of jurisdictions, just going to say it, you have to bribe people. And they're getting in trouble with that with Iraq right now. Pfizer is tied in with some lawsuits because Pfizer essentially had to bribe people in the government. And Pfizer is saying in their defense that we are not going to be able to work in any jurisdiction that's contested or, you know, politically unstable if you don't allow us to bribe people. And it's an interesting argument.
Yeah, it's kind of crazy because there are I know about this through an engineering company that does a lot of business. They're UK based, but they do a lot of business in the Middle East and in Russia and stuff like that. And they got investigated by the English, basically the English version of the SEC or whatever, investigated them for improper payments and stuff like that. Basically, one of the guys who was acting as like an agent for them in soliciting business was, you know, facilitating bribes was the accusation. Now it's pretty interesting that this investigation came like a week after the CEO of the company made the maximum donation to the opposing party's candidate for prime minister. I mean, it's weird that that's when it happened, that it went, you know, he made a big donation to the conservative to the conservative prime minister candidate, and then a week later, you know, they're being investigated, and it absolutely tanks the stock price for the next 2 years. And then of course the investigation ends with no conclusory findings at all. They had some real strong statements when they started the investigation, but they just never seemed to find the evidence. Anyway, but
you don't need evidence to kill a stock price.
Right, exactly. But the reality of it is, if you're doing business in the Middle East or in Southeast Asia, you're going to be paying a bribe to somebody at some point. I've heard this about Japan. I don't even know, but Japan has a socialized healthcare system.
Yes.
But the reality, the practical application of the socialized healthcare system is that if you want to have care quickly, the doctors appreciate gifts.
Yes.
And when you give those gifts, you get care. And if you don't give those gifts, you get care later.
Mm-hmm. Yeah, it's the same thing. Even in China, even the CCP, you know, they give each other these red packages, and it's like, oh yeah, you know, it's just a donation, you know, it's just a subtle donation. But all of a sudden, your level of service increases. It's weird how that happens. It's really weird how those things are correlated.
Amazing.
Well, and, I mean, there is this question about whether we should be doing business with some of these regimes. I mean, here in Canada, SNC-Lavalin got a real sweet deal at the end of the day because, of course, they're very much connected politically. But the allegations were that they were involved in like bribes with Gaddafi's regime. And some of those bribes were people, like that they were hiring sex workers and so forth and providing the, you know, access. And it's like, is that really the country we want to be? And of course, Trudeau moved heaven and earth and actually had his justice minister resigned over this because there was a deferred prosecution agreement that they were trying to push through. And she was basically saying, I'm not, you know, this is not a political decision. This should be made by the actual prosecutors. And when they were actually, and they were trying to lean on her to intervene. So it was this big scandal that still, I mean, it's over in the sense that people are not talking about it anymore, but there was never any real resolution to it. And it's like, is that really who we want to be? You know, is business enough to justify this kind of thing?
Well, but at some point, somebody's going to want the business, right? At some point, somebody's going to do the cost-benefit analysis, and they're going to say, the level of business is worth issuing a bribe. And here's the argument. If America's not going to do it, do you think the CCP, do you think those other countries are going to have any scruples about doing it? I mean, they'll do it. They'll pay the bribe.
So I've been
They won't call it a bribe.
Sage V in the chat asks why I'm not covering the Chandler Halderson case. I have been covering it at night, sort of. My schedule so far at the beginning of January has been a real disaster on the home front. Things have been awry in the Requena house. I've had to do a lot of driving during the day, so it has not allowed me to sit down and actually stream through a trial yet. And so I've been covering it at night a little bit. Yes, Chandler Halderson's trial has been delayed by a week now because he has the coof. That came out yesterday. But no, we've covered some testimony in the case, and I'm pretty sure he ate his parents, at least parts of them.
So is that the conclusion right now? It's looking like a guilty?
I don't know if he's guilty. I'm just thinking, look, I'm guessing there was some nibbling going on. That's if I have confidence in anything.
I know nothing about this case, so I did not pay attention to it at all. So I'm just believing you, Nick, which is my first mistake.
Look,
as the famous advertisement says, just because you did it doesn't mean you're guilty.
Yeah. I have no idea. The prosecution's case against him is really, really strong. I'm just saying, if you've already murdered and chopped someone up, why not take a bite?
I mean,
what I'm
otherwise it's
thinking.
just wasteful.
That's What do you do? You hit a deer, the back end of it's still good. You carve the meat up and you take it home. No.
And that's how you get worms.
The shakes when you eat the people. When you get the shakes. It's not good. It's not good. Don't eat people. Cannibalism's bad, okay? New Age Cuck says
So Jack Murphy is messaging you. Great, good. Okay, cool.
It says, I'm not defending him, but why was he held and not given bail like the African-American child in Texas that pew-pewed his school? Well, different states is one of the reasons. Another reason is probably because the circumstances of the shooting are different. And that does matter. The kid down in Texas who shot up his school did so after a fight. He seemed to shoot people who were at least proximately involved in the fight. Like the teacher wasn't involved in the fight, but was there to break it up and stuff like that. It's more from a conceptual standpoint, it looks more reactionary rather than planned. Whereas with Ethan Crumbley, he brought the gun in the backpack to school. I don't know. These are my guesses as to the reasons. I know people will go a different direction on the reasons why bail was offered to one and not the other. And those may be true, but you're talking about two completely different states with different standards and different laws and different judges, frankly, that are looking at this. So, it's hard to make a determination. If they're in the same county, you could start or same state first, but then same county, especially, you could really start to ask more questions about it. But we don't have information about it. But so you're free to think what you want. I don't know. It could be legitimate reasons. It could be illegitimate reasons. Nico says, can Runkle please elaborate on the algorithmic ban of guns? How is it used to ban guns? How does it work legally?
So basically what happened here is they listed off a whole bunch of guns that were banned, some in terms of categories and also some in terms of specific named models. And then after that, they went and they looked at the firearm registry, which only covers some firearms here, but some firearms have to be registered. And they ran an algorithm to decide which of those registration certificates were actually covered by the ban. And so then they issued out notices of revocation in my view, they're notices of revocation. They say they're not. They say they're just information, and there's actually ongoing litigation. I'm fighting them in court over all of this crap. But basically the question is, how did this algorithm decide that this gun is an AR-15 versus, a Luger versus nothing at all? And they have very much resisted actually providing the details of that algorithm. So that's an interesting fight, but they've been ordered in one of the cases to disclose the algorithm. And which search queries they fed into it and so forth. So that'll be really interesting to see, because they may actually have to justify, how do you think this gun is on that list? And they're really trying to play fast and loose, in my view, with what they're doing here. So the joys of gun control.
And this is exactly why they fought for so long, having a digital registry in the United States. It's one of the NRA's platforms for a long time. It's one of the things that we actually codified in law was, no digital registry, because look, maybe they'll say when they pass it, they'll say, oh no, we just want a registry. That's all. But then later on down the line, they can implement algorithms which do all sorts of crazy things, right? That
The only real purpose for a registry is if you want to come back and ban guns later and you want to find those guns to ban them.
Yep.
Because here we've had registries for handguns and whatever else, and people say, oh, they can solve crimes with it. Well, they never do. They just, because if you got two guys shooting each other at the street corner because they're dealing drugs, neither of them has registered their guns. I always
wait.
like
What
to
are you
joke,
talking about? Drug dealers don't follow like gun registration laws. Like people who are involved in routine criminal behavior don't like go to the government and try and get their fingerprints taken and all of that stuff. They don't do that.
It's really surprising. And, for a lot of things you want to do with a handgun here, you've got to get what's called an authorization to transport, which is permission to take the gun from one place to another. So every time there's one of these shootings at a street corner, I always joke like, oh, this should be real easy to solve. We'll just pull all the authorizations to transport and see who got a permission to go to that street corner for the purposes of committing a murder. And, that's the guy. So, and maybe we should have a talk with whoever. I mean, of course, they're not actually. It's so stupid, but they solve no crimes. Every once in a while, they trot out some like, oh, we've solved a crime with the registry. And it's always so ridiculous because in one case, and they actually got rid of the registry for long guns. So most rifles and shotguns and so forth are not on the registry anymore. But when that was happening and the police were trying to sort of save it, they trotted out this case saying, look, we solved one with the registry. And it was this kid who'd used his dad's gun to rob the local bank, but he'd done it with no mask in this small town. And so like he walked up and apparently the clerk had addressed him by name and said, hey buddy, are you sure you want to do this? Like,
That's very Canadian.
And he's like,
buddy,
yeah, I do.
Hey, buddy,
well, like,
you sure you want to be robbing the bank, eh?
oh, they like, hey, Johnny, are you sure that this is what you want to do? And he's like, shut up and give me the money. And the kid was actually in custody before they found the gun. And I'm going, how's this a registry solve? This is, you had the guy recognized in person by somebody who knows him personally. Like, you don't need the registry for this.
Wild. Real quick, going back to that bail question, Agrilith pointed out a huge effing difference between the Texas shooting and the Michigan shooting. In the Texas shootings, no one's dead. No one died.
That does tend to matter for a bail hearing.
Yeah. If you attempt to murder people but fail, like you're probably going to get bail unless something dramatic, unless you're like, I'm gonna kill him again. Right. Like unless you're really, really out there, but your bail is a right that is rarely revoked. The case of mass shooters, if you don't kill someone, they're going to set bail really high, but and I think his bail was really high. If I remember right, it was quite a bit of money, but yeah, that's the critical difference there. There's no question as to why there's a disparity here. If 4 people are dead versus no people are dead, and the 4 people dead doesn't have bail and the no people dead does have bail, it's the 4 dead people that made it so that the one doesn't have bail. That's your answer. 75K for shooting 3 people. Well, that's a little low.
Well, there was the Waukesha bail that was pretty low, right?
Yeah, that was good. Bail reform's a big theme around here. They're supposed to set bail based on your ability to pay, which doesn't make any sense.
That makes
to me.
no sense.
It doesn't make sense. But they're like, well, but then poor people can't get bail if they've done some heinous act because bail's at like 2 million, and it's like, and a rich person could pay 2 million. It's like, yeah, but I mean that's not how but that's what they've done. I don't know. I'm not the guy who makes the rules. Don't be mad at me about it. I think it's stupid too.
Equity.
I mean, we've got such a different system here in Canada. Like here, the rule is that it should be set with your ability to pay, but most bails are no cash bails, so they've got an amount. Like if your your bail is set at $1,000, which is a fairly common amount out here, because you can't actually borrow money for a bail from like a bail bondsman or anything like that. But you don't actually put up the $1,000. It's just that if you breach it, they can come after you and say, now we're going to sue you for that $1,000 for breaching your bail. Basically, it's very different.
It's so good. Here in Minnesota, they assign your bail, but you can get a bail bondsman, and you basically pay the bail bondsman 10% of the bail amount. It could be less, but typically it's going to be 10% of the bail amount, and then they put up the rest of the money.
I kind of wish that dog had found Brian what's his name? Laundry, because that would have made him relevant again and made bail bondsman trend again. In terms of TV shows, but that's unfortunate. Dog had his day.
So someone was asking about how they determine in Michigan who is the how you get tried as an adult versus a juvenile, and I've got it from Gable and Associates. This is a Michigan criminal law lawyer website, so they have it here. According to the Michigan Probate Code, if a juvenile 14 years of age or older is accused of an act that, if committed by an adult, would be a felony, the juvenile court judge may waive jurisdiction and allow the offender to be tried in the court that would normally have criminal jurisdiction for the offense. Additionally, Michigan's juvenile waiver law of 1997 lowered the age that a juvenile can be sentenced as an adult for a violent crime, and children as young as 11 have been tried as adults for murder because of this law. So basically, the standard is, if they committed the act as an adult, would it be a felony? If it is, then they have the ability to be tried and convicted as an adult. I mean, that's the long and short. Now, it is discretionary by the juvenile court judge. They could take the case but that's going to be the difference between a shoplifting or a theft charge and a murder charge. A juvenile court judge probably isn't going to have like a felony theft charge unless it's accompanying by something else going up to adult court, but a murder charge, they'll let that go up.
Right.
So that's the answer to that question. Ryan Dunson CFE says, this is the greatest boomer stream ever. I'm having a great time. Oh, thank you. Yes. Yes. I was not prepared to do a live stream at all today. I had zero, because I didn't know that this was coming. I was going to be streaming maybe in like an hour or two. What was I going to cover? Oh yeah. I was going to cover the Edgecomb pretrial motions. Are you familiar with the Edgecomb case?
No. What's going on with that case?
Well, he's either a villain or a patron saint. He murdered an immigration attorney.
Oh boy.
Allegedly. No, he definitely killed the guy, but he's claiming self-defense. This is in Wisconsin. And he says that the attorney was rushing at him with a knife when he shot him. Huh. So I was going to cover his pretrial motions. The guy who
was it his attorney?
No, it was like potentially a road rage incident.
Oh,
and so like he's on a bike on the sidewalk and on the road, and the attorney's in a car and like kind of runs him. I say runs him off the road. The guy goes off the road as the car is approaching, but the car doesn't like hit him or anything. And then he keeps going, and then the attorney gets out of his car and pursues him, even though he's on a bike. But I think he gets to like his house or something, because it's like he's going into the gated area when the attorney catches up to him. And the video is really grainy, but he says there was a knife and that he was trying to kill him, which in that case could be self-defense. He gets very close. Again, it's hard to see on the video how close, but it looks pretty close. Like almost.
Wait, do we see a knife?
No.
Okay.
No, I could pull up the video, but it's really hard to see.
We can always pinch and zoom. I mean, that's going to solve the problems here.
Yeah, that'll do it.
And as I see, the immigration attorney, He doesn't look like he's got any credentials that'll protect him against the this case here. This looks like this might be one where maybe it's self-defense very clearly based on the some of the factors.
Let's see. I don't like the way you're laughing after saying that.
I'm just saying. I'm looking at the credentials. This is Milwaukee, and I'm just saying.
Yeah. I think I see the credentials you're talking about. Just have to say, you son of a bitch, we're talking about it in that way. Here, let me make sure I've got the audio turned on this. We can watch the video. It's only a couple seconds. It's only like 30 seconds long. Okay, so yeah, it starts like right. Okay, anyway, here we go.
It's video likely to be key evidence in Theodore Edgecomb's.
I'm gonna mute that guy. I don't want to hear him. So this
from Brady Street.
The guy on the bike. This is the shooter, Edgecomb, on the bike here, and this is the car of the attorney. So we saw the shooter. Let's go back without this idiot talking. So that's where he gets out, but it's going to cut back. So here he is. He goes around driving on the road. Attorney comes, doesn't even slow down at the intersection. So he's after him there, pulls up.
Oh, this is bad quality.
Yeah.
I mean,
that's it. That was it. I mean, that was the whole thing. There's a little bit more, but right as he gets up to him, this is like a traffic camera. I'll try and pause at the exact moment.
Has there been any details?
Okay,
about...
see, it was right.
Oh man,
right there. You can't see it, but he pulls his. I mean, this is where he shoots him. He shoots him right here as he's going up. It is brutally bad quality, but you can see his blob moving up towards him, and he comes there. There's like he gets pretty close.
That's real close.
Yeah. So if he's got a knife, I mean, unless there's something ahead of time where the guy on the bike provoked that attack in some way, like if he did something to him on the road, if he did something and then got on the bike and ran, and the guy got in his car and chased him, there's some questions there. But I mean, if he's got the knife,
if he's got a knife, what else are you going to do there other than pull the trigger?
Yeah. So it's not like he shoots him from a long way away or anything like that. So it comes down to the reason I'm kind of interested in this case is it's in Wisconsin, because all the murders are happening there. It's the happening place. But it's a self-defense claim that doesn't have the level of evidence that Kyle Rittenhouse had, or even like Kyle Carruth and Chad Reed, right? Like we've got pretty clear video of what happens. And the question is on the technical nature of when the shots are fired, what the legal analysis is, sort of. That's not going to be a jury
we're going to
question.
have the driver of the car, because I saw when I was reading this that he was the passenger, the lawyer was the passenger, so the driver probably was there and probably saw a good amount of it. So we're going to have eyewitness testimony, but not technological testimony.
Right. Yeah, we won't. And so it'll be a question of credibility. The shooter has a slew of petty crimes against him, but those petty crimes are coming in. They involve a gun crime, a petty gun crime, having either firing or having a gun while intoxicated is one of them. He's got a DUI collision or something that resulted in injury, for someone else. So he's got a little criminal history, but nothing felony level. So that stuff I believe is going to come in because gun crime makes it somewhat related. So that'll be
any indication at all about what this beef was about? Like, why is there this road rage thing going on?
I have no idea.
Well, it looks like if you looked at the video in the beginning, it looks like the car was kind of like swerving over. So maybe at some point prior, there was an incident on the road, but we didn't see out of frame.
I mean, the problem with road rage stuff is that it varies from like, really understandable. Like, we could have something where the cyclist gets annoyed at him, knocks on his window with a gun and says something, like those kinds of understandable, you'd be pissed if that happened. To things like, hey, this guy was going too slow in traffic, so I decided to
go.
ram him off the road.
I
Like,
might be able to get
go
the
nuts
complaint.
on road rage situations. It's
Yeah,
Let me-
Patrick, in that part of
Whoops,
Kentucky.
that's not what I want.
That
Let
part
me
of
see.
Kentucky.
Yeah, Theodore Edgecomb complaint. They
Oh,
just
somebody was asking if the shooter was Gage Grosskreutz. No, it looks like he got a shot off fairly quickly, so not Gage Grosskreutz.
Definitely
damn.
does not look like Gage Grosskreutz. He has both of his biceps.
Oh, man. Come on now. That's rude. Let's see.
Somebody asked, by the way, in the chat if how the civil suit for Mr. Bye Bye Bicep is going. I don't know if that's been thrown out yet, but I don't think that one is gonna get that far. That's just my 2.5 cents.
Some attorney popped up in my comment section. He was like, "Oh, he's not required to disclose that he had a gun at the event." And I think that's treading very, very.
I mean, he might not be required to, but it's still going to seem suspicious as hell.
Yeah.
It's a material non-disclosure.
Yeah.
Very, very material non-disclosure that he had a gun there in his hand and tried to use it before getting shot. And that
the other thing I really like
and that
about
his
this
gun was in violation of his
License.
revoked carry permit. So he was committing a crime that really kind of matters, especially in that civil law context.
Well, and the other thing I really like for self-defense on this one is the direction of travel, which is guy on bike is trying to get away and the guy who gets shot is the pursuer. Like, that is always helpful. Because then you're just like, hey, if you didn't want to get shot, you just stop running and it doesn't happen.
Yeah, and he didn't have anywhere to really flee. If that's, he's kind of going up there. It seems like he was kind of.
It seems like he was backed into a corner there.
Jonathan Black is testifying in the case as well. He is the use of force expert that did not actually get utilized as a use of force expert in Kyle Rittenhouse's case. I am trying to find this document because there's statements from the wife, the widow, who was the driver of the car. And she said something along, it says, in the complaint, prosecutor said the woman claimed she initially had to swerve the SUV to avoid hitting Edgecomb, who was on a bicycle that night. What the heck? She recalled her husband saying, according to the complaint. She said when they stopped at the light at North Humboldt Avenue and East Brady Street, the bicyclist pulled alongside them on the passenger side, leaned into the front window and asked Clearman, "Are you talking to me?" She said her husband said yes, and Edgecomb punched Clearman and rode off, the complaint said. So that's going to be a problem for him.
Yeah.
If that's true.
That's definitely a huge factor.
Yeah.
Provocation, maybe.
Yeah, it's absolutely provocation. The question, so does he regain his right to self-defense?
By fleeing and then him getting chased down. Yeah.
The person is identified in court records as Clearman, who is seen walking towards Edgecomb, who is identified as a person on the bicycle. Edgecomb's lawyers said their client will testify Clearman was the aggressor and rushed toward him in a fighting stance, yelling a death threat with a racial slur attached. "I'm going to kill you now, slur." The September filing said. Edgecomb recalled Clearman saying before raising his arm.
See, these things are going to come up now,
There's been some, the state has rebuttal evidence. That's going to be a tough sell to a jury. This is an immigration attorney. I don't know what people know about immigration attorneys, but they tend to deal with people of various cultures and actually kind of like them because that's their clients.
He might be biased. I mean, he might just take a certain type of clientele. Who knows?
Yeah.
Who knows?
I do immigration work, but I don't take the blacks. Would be a strange approach, I think.
That's something people usually put on their webpage in any event. And I mean, it might be really hard to actually establish evidence on that. Like,
yes.
I need to call Mark Richards and ask him what racial slur this attorney used when attacking the man. Mr. Richards, yeah, he said, can you imagine? Oh my gosh.
And this is just sort of like was he just really going out there and like kind of white knighting because his wife, he was trying to go out there, his wife was driving, and he's out there kind of pissed off and doing a little bit more than maybe he'd do if he was by himself. I don't know.
He got punched in the fucking face.
if that's true. If that's true.
It's self-serving by the wife. To say that her husband, who was just murdered, got punched in the face and was trying to confront the guy. But it's also self-serving of the guy to say that the husband was an aggressor and shouted the N-word.
Yes.
I'm going to kill you, N-word. But maybe he was. I mean, who knows? If I got punched in the face, I don't know if I'd chase someone down and say, I'm going to kill you, N-word. I would use better slurs. Forever Cuber says, Nick, I just found a Zod rune. Lol, dropped off of Shank. You lucky mother. Oh my God, you scumbag. Good. Congrats, buddy. Sorry, that's Diablo 2 stuff. Marcel Dufour says, a witch was casting a spell that would cause harm to you in front of you. Could you punch it to protect yourself? Knock the Lord into her.
Knock the Lord into
Jesus.
her.
So yeah, I don't know that would fly. If you would have to have an objectively reasonable belief that her witchcraft would harm you. That's the hard part there. Knee Deep X123 says, thank you, or Ty, I think he says, thank you, Mr. Ricada, for the content and knowledge. Keep up the good work, making day drinkers of us all. That is my mission in life, is to have everyone day drinking. Koi 540 says, if you are convinced someone has committed a federal crime like bioterrorism, what are the laws around citizens' arrest for federal crimes? If the person you think is bioterrorizing someone is an agent of the state, do not engage in citizens' arrest. Let me just put that out there right now before anybody has any ideas about that. But your ability to citizens arrest an alleged bioterrorist is going to be minimal unless you catch them in the act of bioterrorizing. And I don't mean through some sort of injectable. I mean bioterrorizing by like putting a backpack full of arsenic or anthrax spreading devices, spraying a gas of some sort into a ventilation system. Like that's about the only time you're going to get that. Don't do it. If you're talking about what I'm thinking you're talking about, please don't. You will be killed by many feds.
I know exactly what they're talking about, and I would echo that. Do not do what you think you're going to do.
Yeah.
Yeah, this is all manner of bad idea.
Yep.
Yeah.
Mo says, hey, virgin earhole pegged IT invalid. Why is your local stream so much clearer than the YouTube one? It has to do with running my camera through OBS and then through StreamYard. It's a mess. It's a mess. That's the main reason. Also, some people don't like the bokeh effect of my camera that I use for this, but to those people I say, too bad. I like it. I like it. But yeah, so as far as Ethan Crumbley goes, I mean, there's nothing else to really talk about. I was thinking about streaming that Edgecomb hearing. It's an hour and a half. I don't know what you guys are up to, but it's late for you.
Well, it's 6 a.m. Oh, I'm working. I'm burning the midnight
early.
oil. Yeah. I got some work I was jumping on. I'll probably jump off here for a second. I got my stream going off at 9 o'clock, but I'll be around for that. Speaking of which, as somebody calls me with work-related stuff. So yeah, I'm going to jump off for that. But guys, I'll catch you guys later on a future stream. Nick, I know you'll probably be doing more daytime streams once you get your shit together, right?
Yes, I was supposed to already be doing them. It was supposed to start in the first of the year, but then our nanny decided to take like a vacation or something. And now she's back, and I'm still having to drive all over the town, which is very irritating. But I think I am going to be covering the Edgecomb trial, which starts on either the 17th or the 18th. And once that thing's in full gear, I mean, I'll be doing the 9 to 5 on it. So
I'll jump on that for sure, guys, for sure.
Yeah, and I'll be continuing to cover the cannibal. I mean, not the cannibal, the guy who allegedly killed his parents and chopped them up.
See, this is your problem, Nick. When you are Chicken Little of cannibalism, nobody's going to believe you anymore. So when the true cannibal comes up, it's going to be, hey, well, Recaita's already called cannibal. He's cried cannibal 99 times, you know?
Counterpoint, I've cried cannibal once, and what if he's the true cannibal?
On that note, I'll talk to you guys later.
That was Legal Mindset, guys. Feel free to go subscribe to his channel. It's linked in the description of this live stream. Let's see. I do have some more super chats to read through. Oh my gosh, I don't have Odyssey pulled up. I am not ready for this. Runkle, it's like I don't stream at all. It's like I don't know what I'm doing.
I am still trying to figure out the whole YouTube thing. It's a challenge.
Well, the problem I have is that my computer had a force reboot, and right before I got everything loaded up, so I was not prepared, and I tried just jumping. You missed it. The beginning of the stream was just me boomering through audio issues entirely. So that was a mess because all of my audio stuff got undone and was not turned on anyway. So I still have to go back and fix all that. So that's great. But yeah, so I do have I have super chats to read through. And I'm trying to decide if I want to do the Edgecomb hearing now. What do you guys want? I guess I'll just ask the chat. Let's put up a poll. Edgecomb pre-trial hearing. Watch party. Do it now. Do it later. Oh, wait, I have... Okay, let's see. You guys get to decide. You guys get to choose. So there you go.
And I'll probably dip out. I've got a video that I've been trying to get recorded, and life keeps kicking me in the butt every time I try. It's like you sit down and then, oh, look, new thing comes up. So
yes,
I think I'm going to try to wedge that in.
All right, man. Well, thanks for popping on for a little bit, guys. You do need to check out Runkle of the Bailey's channel. You can get information on Canadian firearms law, but you can also get information on firearms in general and other topics as well. Make sure you check it out. Also linked in the description. Just hover over his name, click on it, and it'll bring you right to his channel page. And you can hit that red subscribe button. Make sure you click the bell on everybody. You got to click the bell.
And one of these days, just because I've been getting a ton of requests for it now, I'm going to have to get a bow and go out to the range and shoot some targets just because I'm getting too many logless requests.
Yes. You got to do it. You got to put like statutes that you hate on the target and fire arrows into the statutes, right?
Oh, I don't know. That would be a lot of arrows that I need for all the statutes I dislike.
Look, I mean, do you think elves are short on arrows? Like, what do you think? What are you thinking here? Yeah,
that's fair. I mean, just sadly in real life, those things are stupid expensive, at least for halfway decent ones.
To the Odyssey people, tell Odyssey to put a poll option up. Until then, I don't know how to make you guys be able to participate in the YouTube poll. And no, before you even ask, I'm not going to make a separate website poll for people to go to. No, I'm already lazy. Anyway.
All right.
All right.
I'll catch you next time. Cheers.
All right, man. I'll talk to you soon. Peace. Okay. Okay, let me get this pulled up. That's what she said. The Edgecomb pretrial motion hearing. So someone on one of my chats, and yes, I do know it's Wednesday to the Discord people, and we will make live chat Wednesday occur at some point here. I just have to figure out what that looks like. Edgecomb pretrial. Here we go. So, just so you guys know, someone in one of my chats said that Law and Crime was annoyed that I was utilizing their live streams. I can't verify if this is true, but they were annoyed that I was utilizing their live streams for some of the content that we do, because apparently they think that public court proceedings are theirs or something. I don't know. So in honor of that, I'm going to use Law and Crime's recording of the stream to talk about it. And the interesting difference will be that Law and Crime records a court proceeding. They do that. And I'm very thankful that they tap into the recording that exists and broadcast it out on YouTube. I know other places do too, but they do it a lot. And it's really great of them to do that. But what I'm going to do is I'm going to add a significant amount of commentary and conversation and jokes and other things to make the stream significantly more interesting and hopefully more insightful than what they are doing. 1 second. I have to send a message to they are a broadcast channel. I am a commentary channel. We provide different types of content, and personally I prefer mine. Let me see. I'm sending a link now. I'm going to invite other people to watch this with me. Let me send this to one more place. Mm-hmm. Let me see. Do I have... I know this is the best stuff, but look, if I can add value to the stream with a message to someone, I want to do that. So all right, I've sent messages. I don't know if anybody will join me. It might just be you and me, chat. It might just be us. Do we want this big, or we should do this, right? As long as it's just me, we don't need this big. If something pops up, I don't think it's going to. We can always enlarge the screen. Oh my goodness, we've got this. Mo says, sorry for the mangled text. YouTube Nazis are blocking super chats if you use bad words. Anyway, serious question. How is jury duty not slavery? It's a very good question. I don't have a good answer for you. Koi 54. Oh, because they compensate you. That's probably the distinction that they make. Koi 540 says, got it. Leave the white collar bioterrorism to the alphabet agencies who probably have zero conflict of interest in such an arrest. Blue collar bioterrorism is potentially fair game to stop. Yeah, honestly, that kind of nails it. The great Cornholio says, about to bioterror this Taco Bell, send the glowies. No. Let's see. What else is there? Is there anything else? I think we're about ready to begin. I think we're about to ready to begin here. So let's kick oh wait, I guess I should tweet that I'm doing that too. Oh my God, everything you have to do for this. Retweet this, quote tweet. That was a really short hearing. Now I'm going to review the Theodore Edgecomb pretrial hearing from the other day. Come join the stream. I should have capitalized come join the stream, but okay, tweet. All right, here we go. We're going to get this thing started.
Wisconsin versus Theodore Edgecomb, 20 3535.
Yes, it sounds like garbage for me too.
Afternoon, Your Honor. Anik Ahmad on behalf of Theodore Edgecomb.
Biabi Lamar also on behalf of Theodore Edgecomb. All right, the case is here today on a number of motions, some motions in limine, some other issues that need to be addressed. I'll hear from both sides, but I think the first one in date order was the issue of the defense asking to call Mr. Burrams, Burems, and the state objecting at least to, if not the.
Could I pause and give you a summary of what this is about? Yeah, this is about a guy who shot an attorney following some sort of road rage style incident. He is claiming that it is in self-defense. This happened in Wisconsin. And this is a pre-trial motion. So they're motion hearings. So there's a couple different motions. Some of them that the judge mentioned, motions in limine. Motions in limine are to eliminate evidence at pre-trial so that it doesn't have to be brought up and argued over at the trial itself. They'll argue ahead of time about them. So that's what this hearing is for, to determine if some of this evidence can be brought in. Like, for example, the guy's criminal history and stuff like that. Potential witnesses, character evidence. Can they call the dead guy a victim, for example? These are questions so that they are going to handle at this hearing. David M says, whatever happened with the Ed Greenwood interview? I just need to follow up with him on it and set it up for a time. With the holidays, it's been just a disaster. So here we go.
The testimony, or the expert, at least some of the testimony. Any reason we should start with something other than that?
However the court wants to begin with it.
All right, well, why don't we start with that one? The defense named him, the state's objecting, so why don't I hear the state on the objection to calling Mr. Burrams? The objection being that apparently Mr. Burrams wants to allegedly testify that the force used or the behavior of the defendant in the day in question was, quote, reasonable, end quote. Go ahead, Mr. Huebner.
Yes. So, Your Honor, I filed a brief. I don't necessarily want to get too much more into it, but I would just simply indicate that under Wisconsin law, Detective Burm, or former Detective Burm, Mr. Burm's testimony as to pretty much everything as to the self-defense, it's not admissible. Law of self-defense is defined in statute, and Wisconsin Jury Instruction 805 clearly describes how that's going to be delineated to the jury. It involves the jury making decisions as to whether or not the defendant actually and then reasonably believed that there was an actual or imminent unlawful interference, then that he actually and reasonably believed that the amount of force used or threatened to use was necessary to prevent or terminate interference. And then the last one was that it was reasonable. The question we have here in this is the state of Wisconsin's Court of Appeals has defined self-defense then as having two components. One is subjective, which means he actually believed, and the second is objective, which is what the jury has to determine whether or not said beliefs were reasonable. And this spells out in this case because, and as the court knows, we still haven't amended information. So this will spell out first-degree intentional homicide. If actual and reasonable will be spelled out to the jury and how it plays out into lesser included of second-degree intentional, first-degree reckless, second-degree reckless. The defendant is the only person who can testify as to what he actually believed. Mr. Burm's opinions, they're irrelevant as to that. Whether or not Mr. Burns believes that the defendant actually believed it, it's irrelevant. No witness is allowed to testify as to what another person believed, or more importantly, what the defense is attempting to do with Mr. Burns is to get him to say that the defendant is being honest about what he's saying, and you can't do that.
Right, let me jump in. That's clearly the law. So defense have something I'm missing? Because that's absolutely correct. No witness gets to say another witness's actions, in this case, the defendant's actions, were reasonable.
Okay, so what the defense is trying to do is use their use of force expert to say that the use of force was reasonable. The prosecution is arguing, the bald guy is the prosecutor. He is arguing that they shouldn't be allowed to do that because they can't testify that to what someone else believed. So the expert cannot testify that the defendant's actions were reasonable subject to the defendant's understanding. Now, the question, though, is can the use of force expert testify that the actions or that similar actions would be objectively reasonable? Can he testify to that fact as an expert? If someone was in this situation, this and this and this, would the use of force be reasonable? Well, my opinion, yes or no. Not applying the facts of this case, but maybe a hypothetical that's nearby. That my guess is that the defense is going to say, oh, we don't want him to test about the subjective beliefs of our client. We want him to testify about the objective standards for reasonability or reasonableness in regards to use of force as a use of force expert. Is this objectively reasonable? We want to handle that objective standard. And this is the guy to do it. You know, that's what I'm assuming the defense is going to say here. Eric Johnson says, don't you hate when that one hair messes up the comb over? This hair is just sitting here. It won't sit down. It's standing up at the school board hearing or whatever. But yeah, so that's what's going on here, and we'll see what happens. But I wanted to also pause this. Ryan T, happy 33rd birthday, man. Cheers.
They don't get to comment on the accuracy or validity of a defendant's statements. They don't get to put themselves in the position of the jury. The state's correct on the Richardson case.
Your Honor, first we'd like to bring to the court's attention that Ricky Burrows was to testify on two different issues. The first issue involving investigation and the standard norms involving the Milwaukee Police Department is not at issue, but we did want to kindly note that Ricky Burrows was to testify on two issues. As to the second issue that is brought by the state's objection regarding the reasonableness of Mr. Edgecomb's force, we would concede that Mr. Burrows to not provide testimony as to the ultimate issue as it relates to the reasonableness of Mr. Edgecomb's use of force. However, we do believe that Mr. Burrows should be able to testify as to potential threats, what a use of force is, the use of force consortium. We believe that his testimony would be helpful for a jury's understanding up to at least what constitutes a threat in that regard. That would still allow the jury to be able to decide the ultimate issue as to the reasonableness of Mr. Edgecomb's actions. So for that purpose, we have conceded with the state as to the ultimate issue as it relates to the reasonableness, but we believe that Mr. Burrows should be able to testify as to at least what constitutes a threat. He has, substantial experience in that issue, working as a Milwaukee Police Department homicide investigator, has testified numerous times in his court. So for that limited purpose, we would ask the court to allow his testimony for that.
Your Honor, I'm going to object to that as well.
Yeah, this guy just sold the baby. He just said, "Oh no, we concede it, but we're going to ask for this limited purpose." And then this other guy's like, "No, I'm going to object to the limited purpose also. Not going to do it." I think he should have gone harder in the paint and said, "No, he's here to talk about the objective standards." And he's kind of saying that. But he's like, "Your Honor, it's a two-part test. The subjective reasonableness of the defendant plus the objective reasonableness of doing this. Would a reasonable person do this? We need a use of force expert. This is his job. This is his qualification. This is what he testifies about. He goes to court and testifies about the factors that lead a jury to make reasonableness conclusions under the law of Wisconsin. And that's what he's here to do. That's what we expect him to do. And if the state wants to rebut that, then the state needs to bring a witness who can rebut it, not try and eliminate the testimony of a witness as to the objective measures that an unsophisticated jury is supposed to figure out. They need an expert to help them navigate the complicated nature of self-defense. That's what our expert's here to do. Very, very limp sort of go. And so now the prosecutor, he's like, "No, we're going to object to this other stuff too, because frankly, they didn't lay a very good basis for it."
They're stating that they want Detective Burns to testify as to what is a threat, and then to also testify in their moving papers as to the continuum of basically what they're referring to as what an individual law enforcement training is in the continuum of the use of force. First of all, Detective Burns testifying as to what something is or is not a threat is simply them attempting to get Detective Burns to say that the defendant is telling the truth, that he thought it was an actual threat.
Right, which is not going to happen. That is not going to happen. No witness is testifying to that, period.
So
yeah, he cannot testify to the subjective truth of what the guy believes.
There are citizen witnesses, as well as there's 4 of them, as well as the defendant. All of them can testify as to what they saw, but no witness can testify as to whether or not, even those 4 that are there, that they thought someone was acting in self-defense. They can testify as to what people's demeanor were like. They can testify as to how actions were, but they can't. No witness can sit there and state that they thought something was threatening to the defendant. The only person who can do that is the defendant. They can describe what they saw, and then it's for the jury to decide. The next thing the defense wants.
It's partially true. I mean, he's saying it very convincingly, but a use of force expert can testify. That's the whole point of having a use of force expert, is that they can testify to what would constitute a threat, what types of threats would be responded to with what types of force. Now, if they brought him in and in their moving papers, as this guy said that he would talk about the police use of force continuum, then frankly, they're retarded. This guy is not a police officer. He's not talking about the police use of force continuum. If the only expert they could find was a guy who's going to testify about law enforcement's use of force continuum, then they didn't do the work. There's someone out there who can testify to civilian self-defense. That's what they should be testifying to. What constitutes a threat, and what is a proportional response to that threat? They don't have to testify to the facts of this case. In fact, Experts are often not testifying to specific facts of the case. They're giving expert opinions on what a thing is to help educate the jury. They're not arguing that very well at this point. This guy's crushing them.
Is for Detective Burns to talk about the continuum of use of force. That's irrelevant. This defendant is not a police officer. He doesn't have that training.
Well, hang on. I presume by the continuum of use of force, that would mean a police term, correct me if I'm wrong.
That's correct.
Of you do this first, then you try to de-escalate the situation with maybe your words, then you use bodily force, then maybe use a nightstick, then maybe a taser, then maybe a gun, something along.
This guy sounds like the Bears. He sounds like that old SNL skit. Yeah, what you do in the use of force, first you got the offensive line, then you got the defensive line of the Bears, then you got Ditka. Ditka is God. Ditka is the ultimate use of force. Once Ditka takes the field, nothing else matters at that point, you know.
Along those lines?
I believe so. It's not spelled out as to what the defense is referring to, but considering Detective Burns is a former Milwaukee police detective, I believe that's what they're referring to. But this defendant is not a member of the Milwaukee Police Department. He's never received that training. As far as I know, he's never received any training. As far as I know, he's never even gone to a concealed carry permit class. So that training is irrelevant as to this defendant. What matters is what this defendant at that moment, what he is going to articulate and what witnesses saw. That's it. What may have happened in some Milwaukee Police Department training and how a Milwaukee police detective states that a Milwaukee police officer would have handled that situation is irrelevant for the jury's decision as to what the defendant was doing that day.
100%.
So all of that for Detective Burns' testimony is irrelevant.
Yep.
It should not be brought in. The case law is very clear. The first part, yeah, if that's what they want to bring in and have him testify as to his expertise as a homicide detective and certain things that he thinks should have been done, fine. They can call him as to that. But attempting to get
why would you get a homicide detective as a use of force expert? Like what I'm maybe there's a disconnect for me, but I don't know what a homicide detective has to say about use of force issues. Generally speaking, that those two do not automatically correlate, right? A homicide detective's job is not to determine use of force issues. They may have some knowledge of use of force. They may have some experience in how cases have played out, but that's not their job. Their job is to determine whether a homicide occurred, justified or not. And then the legal aspects of that homicide would be determined by the district attorney, whether or not they're going to charge something, and then ultimately by a finder of fact. If that's what the defense is doing, then I don't know why they're even bothering.
This jury to evaluate whether or not the defendant actually believes something and then reasonably believes something based on Milwaukee police training he never got is irrelevant, and therefore it should not be allowed in.
Yeah, and if we could respond briefly, we've already conceded on the issue of Mr. Burns testifying to the ultimate issue. So that's not at stake as it relates to the reasonableness. However, Mr. Burns has testified. He's actually been called by the state on numerous occasions, over several hundred homicide cases, and testified to what constitutes a threat. So, he was obviously credible in when it was the state's interest, but now he's doing it so on the defense side, and now the state takes issue at that. A threat is still a threat. He's not testifying as to reasonableness of Mr. Edgecomb's actions. He's only testifying to what constitutes a threat, period. That's all that we're asking for. We've already conceded as it relates to the reasonableness issue. As it relates to the use of force continuum, that is, we understand that to be a continuum that is basically reasonableness. It constitutes reasonableness for an officer and also for dealing and de-escalating situations. Obviously, if a jury is to consider what is reasonable, that could be helpful. But even if the court decides that the use of force continuum evidence should not come in by Mr. Burns, as it relates to what constitutes a threat, again, Mr. Burns has testified several hundred times in this court for the police department on those issues, and he should be able to do so when it's a defendant at issue.
Your Honor, I would like the defense to name me one case where Detective Burms has taken the stand and stated to a jury that he believes something was a threat to an individual. Name one.
So hang on. So would I. Well,
There's a
the
passion.
case number that occurred in Milwaukee County.
Well, the state hasn't asked for any type of addendum to Mr. Brums.
Counsel, I'm asking.
Well, Mr. Brums is not here right now, but
Hang on, counsel. You just represented that he's testified hundreds of times in this court. For me, this court means me. I don't care what happens in front of other judges. I don't care what happens down the hall. I'm presiding over this case. I will make the rulings. So as far as I'm aware, he's never testified in front of me. And I don't recall.
Ooh, his judge sounds pissed. Fired up.
Ever hearing testimony along the lines of what you just indicated. So unless you have a case number that I can look up in Milwaukee County, but particularly one that was in front of this judge, then forget it. You guys cannot just make blanket allegations from the defense without supporting it. You didn't support it in writing, and now it's not being supported on the record. That was a valid request. Name a case now, or we're moving on.
Mr. Burms can testify to the cases that he testified in.
Name the case now.
We don't have the information.
And he's not
at our
testifying.
disposal right
Done.
And he's not testifying.
As to that issue, Your Honor?
Counsel, right now, he's not testifying at all because you guys have not given me anything that would indicate he can provide relevant testimony to this trial.
Well, Your Honor, we'd ask that we would have a Dauber motion where he would be able to provide such testimony.
I don't honestly see the point of that.
I mean, he's testified in several.
If you want to hear what losing a motion hearing sounds like, this is a good example. This is not going well for the defense right now. They're getting wrecked.
Cases, the
counsel. He's done it with other judges. Argument does not work with me. Mr. Huebner knows that. Mr. Ahmad should know that. I don't care what other judges have ruled. Period. Now, if the Court of Appeals has made a ruling, fine. If the Supreme Court has made a ruling, fine. But just because someone allegedly testified in front of a colleague on a nameless case where I don't know what the merits of the case were, I don't know what the allegations were, was it a homicide, was it an armed robbery? You can't just throw things out there like, well, he's testified hundreds of times. I've never heard his name. He may have at some point testified in front of me because I've had hundreds of homicide trials, but he's never given testimony like that. Mr. Burns is not going to take the stand and say that your client's actions were reasonable or that they were unreasonable. That is the province of the jury, period. Let's move on.
Damn. So what just happened there? The defense's expert just got ixnayed from the hombre. He's gone from the case. They're gonna, if they want to get their expert witness on use of force in, they will have an uphill battle of well pleaded motions to get a Dober here, a Dober hearing. To get him qualified, because right now the judge's like, no, it's a waste of time. They will have to file and you know what? It's their job to do that. It is their job to ignore the judge properly on his ruling here and to say, Your Honor, we recognize the ruling of the court. We would ask for reconsideration and a motion for a Dober hearing based on these factors. Here is a clear articulation of what we want him to testify to. Here is the case law supporting that. Here are other cases in which he's testified that we were talking about. We apologize profusely to the court for not having a citation ready. We did not believe that we would need to cite an exact case in front of the court, and we wanted to make sure we got a case number that was on point, that had analogous types of facts, self-defense, homicide, not law enforcement. And here we go. We found it here, and here where he has testified. It's in his CV. He'll be testifying to this at his Dober hearing, and he can be examined, cross-examined by the state to allow them to rebut the fact that he testified this way in front of the court. And we'll make sure he's prepared to deliver that sort of testimony. Like you better be a fucking apologetic monster, right? Like begging the court to bring this guy in, because you don't want your expert thrown out. That's terrible. Terrible choice. Lydia Schewitz sent a rage quit. Very, very apt. The rage quit sticker. And then Squizgar says, calling it, judge is going to be accused of being racist. He already is. He already has been.
Your Honor,
If Mr. Burns and the defense had better provide some documentation by the end of the day tomorrow, because on top of everything else, gentlemen, I'm tiring of you guys filing document after document after document. We had a hearing 2 weeks ago, and every day over the Christmas to New Year's holiday, another document came flying in. Additional motions limiting, new experts, supposedly new witnesses that were found. I'm tiring of it. If I get some documentation, Mr. Burns could potentially testify about the investigation that occurred or took place by MPD. That's the end of it. Was it an adequate investigation? Yes or no? Was it thorough? Yes or no? But he's not going down the other two paths, period. It's inappropriate, and you guys know it's inappropriate.
Ooh.
Next.
This judge is pissed. He
Your
came
Honor,
into this hearing pissed.
and I don't know if defense counsel would have potentially another thing that they would like to discuss, but I think potentially the next most important motion eliminated by the defense was their motion to exclude.
To people just tuning in, this is the case of Theodore Edgecomb. He's a Wisconsin man accused of murdering an immigration lawyer, not his lawyer, in what appears to be some sort of road rage style incident. He is claiming self-defense in the case. The case will be, the trial itself will be broadcast starting on either the 17th or the 18th of this month. So just next week. And I believe I will be covering it. So this judge seems promising for this case too.
A portion of the poll cam video. The court, we heard arguments on this. The court stated that it would make a decision. It needed a little bit more time. My suggestion here is, and just so the court will remember, this is a video that happens and captures what happens seconds before the one video that we've all seen, which captures the homicide. But right around that corner, there is the confrontation in which the defendant punches the victim in the face.
Right. I've paid attention. There's allegedly 3 confrontations. Some confrontation allegedly that's not caught on camera.
Correct.
A confrontation where the defendant punches before we get into this argument later, punches the victim, punches Mr. Thurman through a window, apparently. Then there's the confrontation that ultimately is the fatal confrontation, right?
Correct. And I'm almost positive the defense is not attempting to prevent us from using the video that shows the actual homicide. There is an argument that the defense is making that the video that shows the punch is unduly prejudicial over its probative value. What I would suggest at this point is, could we potentially show the court the video? And because the court hasn't made a ruling on it, and I don't want, in case the court rules against me, I don't want this video potentially out there in a way in which the jury could see it. I've got my computer, I've got the CD, we can all go into chambers right now. I can play it for the court, and then we can talk about it. Is that fair?
Defense have any objection to that?
No, Your Honor.
Okay.
Fine.
This judge moves with purpose. Oh my goodness. Okay, so the issue at hand here is, so there's a video of the actual shooting, and now there's this other video just prior to the shooting where the defendant allegedly bikes up alongside the car that the deceased was the passenger in. The window is down, and the defendant says something like, "Are you talking to me?" The deceased says yes, and the defendant punches him through the window, punches him right in your fucking face, punch you right in your face. My fist, your face. That's where it's going. Punches him right in the face and then bikes off. And that is immediately preceding the confrontation. So they're going to go back into chambers and review this this video in camera so that the court is seeing it and the public is not. Nobody else. This is unreleased footage as far as I can tell. They're trying to avoid tainting the jury if the court rules against this footage being allowed. To me, this is not prejudicial. better than probative, because it goes to the question of provocation. And I'm assuming that's what the attorney is going to argue. This goes to the matter of provocation, because provocation is a potential instruction that would be included in a self-defense jury instruction, as we saw in Rittenhouse. Plus, provocation can nullify a self-defense claim, assuming the duties that follow provocation are not met. Kingslayer Damocles says it's hilarious watching judges walk back their statements in the next sentence. Goes from "I don't care what other judges rule" to "well, I care about what other judges rule" in a sentence. Well, he cares what other judges rule when those courts have authority over them. The Court of Appeals, the Supreme Court. Tyler Moulter says we all take a beating sometimes. Okay, I'm gonna fast forward this. It's just a little bit here as they come back.
All right, I forgot where we left off exactly. I had a conversation off the record with the attorneys.
Your Honor, where we left off was we were going to be taking up the defense objection to the playing of the first segment from the poll camera.
Right.
There are two segments. One we're very familiar with, but the segment that happens right before it, the defense was objecting as to it being unduly prejudicial. The court has watched it now.
Right. Thank you for the reminder. We discussed a couple of different things after doing that. So yes, for the record, I viewed the video that's in question between both sides. There are allegations in this case that there were effectively three confrontations. A confrontation between Mr. Edgecomb and Mr. Clearman that was not caught on video, that was on Brady Street somewhere east of where the ultimate incident occurred. Then there's a video that I just watched that shows the defendant apparently punching, it would appear, the victim, Mr. Clearman, through the window of the vehicle. And then Mr. Huebner has represented to me that that occurs, and I'm familiar with the area, within seconds, maybe 5 or 10 seconds of what ultimately leads to the fatal confrontation 5 or 10 seconds later, which is just around the corner from Brady Street, as I think they turn onto Holton Street, or at least the bridge that leads to Holton Street. I viewed it. I'll hear from the defense if there's any argument, or if you want to elaborate, please.
Yeah, we're just going to put on a record, Your Honor. We do believe that the video would tend to confuse the jury. We do know the court is, predisposed to admit the video, but we want to just put on a record that we do think the video is unfairly prejudicial on the basis that it would tend to confuse the jury. There was an incident that preceded that altercation, and without, of course, the defense is reliant on the Milwaukee Police Department and its investigators to obtain the video of the first altercation, which has not happened, which the Milwaukee Police Department has failed to do. Therefore, the video that's at issue tends to make it look like Mr. Edgecomb was the initial aggressor without that first video. Again, we do understand that the court is, intends to admit that video, but we want to put that on a record that we do feel like it is unfairly prejudicial.
Again, a shit argument. A shit argument. Well, there's not other evidence that we think hypothetically would show something different. So therefore, this evidence that does show something immediately preceding the event can't be shown. Just a really shitty argument. They have not provided any reason as to why they haven't produced the video. If they think that it's a valid portion of their claim, they need to produce it. Yes, the police have a duty to, or the state has a duty to provide exculpatory evidence when they have it, and they have a duty to pursue reasonable means to acquire it. But if they're not doing it, then you have to try and get it. If you believe that video exists of the prior incident, and if that video will be helpful, then what the hell are you doing? Why are you here? Where are you going with this? I mean, the state has to prove their case, and the state has to go through a reasonable effort to make sure that their case is valid. But that doesn't mean that they have to go move mountains to try and acquire evidence that you believe is out there. If you believe it, you gotta go get it.
So noted. I'm allowing the state to use that video that I just watched. It's the video that shows allegedly the defendant punching Mr. Clearman into or through a car window on Brady Street. It's probative. It's, I guess, prejudicial, but as the lawyers know, all evidence is designed to be prejudicial, but it's not unfairly prejudicial. It's part of the continuum of this incident that occurred.
Yeah. So the just real quick, the rule of evidence on prejudicial evidence, and like you said, all evidence is prejudicial in some way. The question is not whether evidence is prejudicial. The question is a balancing test versus whether it is more probative. That is, whether it is more likely to prove any relevant fact more true or less true if that outweighs its prejudicial value. And that's a really, really low bar. If a piece of evidence has a tendency to show something to be more or less true, then it's getting deference towards being admitted. The prejudicial value has to be very high to outweigh the probative value. So it's called a balancing test, but really the balance always favors the probative nature of evidence, unless it's completely irrelevant to the issue. What we saw in Rittenhouse, them trying to bring in these prior acts, those prior acts had nothing to do with what happened months later when he's at this protest. In this case, we're talking about something happening moments before, 10 seconds, 5 to 10 seconds prior to the video is another segment of the same video. This is all the same event with the same two people happening in the same flow of time. To suggest that it should be removed is nonsensical. And they didn't provide any kind of argument as to why it should not be allowed, just by saying it's prejudicial. Well, it makes my client look guilty, Your Honor. Well, I'm sorry. You're going to have to provide a reason as to why that's not the state's job.
The lawyers discussed or implied that Mr. Huebner might make it seem like that was the initial confrontation. I'm confident Mr. Huebner would not do that. I would hope and expect that the state's going to call a witness or witnesses that will indicate that there were, depending on how you look at it, 3 confrontations. One that was not caught on video.
And they already have a witness for this, the driver of the car, the widow.
And the second confrontation that was caught on video, the punch, and then 5 or 10 seconds later, when there's a turn onto, again, Holton Street or the bridge, what results in the ultimate fatal confrontation. So the state can use it. It's not unfairly prejudicial. It's part of the continuation or continuum of this incident and what occurred over the course of 30 seconds or a couple minutes, all of which the jury should be able to see and weigh appropriately and effectively as they deliberate the allegations in this case. There's a number of motions eliminated. Was there anything else, Mr. Huebner, you wanted to address before I turn to the defense motions?
Well, yeah, these are basically all defense motions, so we can just deal with them.
Basically, yes, but, so the defense filed 3rd motions in limine. The first motion in limine is requesting exclusion of photographic evidence due to the danger of unfair prejudice. Number 2, that's the haircut issue, getting the defendant a haircut. Number 3 is an issue regarding how the state addresses various individuals during the trial, individuals and other persons, either that are testifying or may be referred to during the trial. And then number 4 is the testimony of a potential witness. I heard from the defense on the exclusion of photographic evidence, but I'll just say this. I mean, I've tried by now, I'm sure 100 homicides in my career, if not 100, at least 75 or 80. The state gets to put in evidence that is sometimes gory. It may include a dead body. It may include someone who, I mean, I've seen people that have been stabbed to death, people that have been shot in the head, people that have had rigor mortis set in because their body wasn't seen or found for a few days. The state can introduce that. They can't belabor it. They can't introduce 15 photos of a dead body. because I'm not going to let them turn this into an attempt to, obviously, as the defense mentions, discuss the jury or make it more difficult for the jury to be fair and impartial. But the state gets to introduce the evidence. Usually what I allow is anywhere from 2 to 4 or 5 photos. I've never allowed a state to, Mr. Huebner or anyone else, to belabor.
Note a big difference in the Rittenhouse trial where they were able to show Joseph Rosenbaum's dead body, 25, 30 times?
The state may have 20 or 30 photos of the deceased. They're not going to introduce all of them. Having said that, is that enough of a ruling, or do we need to discuss it further? Mr. Huebner?
Well, Your Honor, what I will say is I've given defense counsel the numbers. I sent them, they already have the CDs, and then I emailed them all the numbers that I intend to use. From the crime scene, there's a lot of pictures of blood. I don't actually spend that much time on the body as much, but obviously the blood and how the body cam, I plan on using one body cam small snippet, because the manner in which the victim's body is found by the police, I think, is relevant, especially to some of what I expect to be claims by the defense in terms of self-defense. The main thing with it, Your Honor, is from the autopsy. And I want to be very clear. I'm not using any of the internal photos. I'm not using, because those are irrelevant for purposes of this. I'm not using large photos of the victim's body. I didn't use any of the photos from the autopsy prior to the cleaning, because that's just got tons of blood. And I think that that gets beyond the point of where I'm going. What is important here is that the victim has a gunshot wound to his head, and there's stippling. And that stippling is important because it's a range of fire characteristic in which the medical examiner will be discussing the approximate close proximity of the barrel of the firearm to the victim's head when he's shot in the head. Now, unfortunately, because it is to his head, I wasn't able to get photos that some of them are a little bit gory. There's 2 that I'm thinking about, and had defense counsel asked me about it, I would have told him, because they do show the eye in a manner in which I think is a little disturbing. My plan was to either put a Post-it note over that when we show it to the jury, or even just cut that portion of it out. We can crop that down. What's important here is for the jury.
Listen to the difference in this prosecutor versus like a Binger or the prosecutors in the Kim Potter trial. Listen to what he's doing here. He's talking about mitigating the impact of the goriness and the disturbingness of the photos. This is like what you're supposed to do as a prosecutor. He's contemplating the prejudicial nature of the evidence of a dead body, and he's talking about ways in which he is proposing. And notice what he said: if the defense had asked me, I would have told them this is what I intend to do. He's talking about his plan to mitigate the impact as much as possible, to not belabor this gory nonsense. We saw it in Kim Potter, where they're showing the blood and the body over and over and over. We saw it in Rittenhouse, where they're showing the bodies over and over and over. Why are they doing that? They're trying to tug on the emotional strings, on the gut strings of the jury. This guy's like, I don't want to show that. The eyes kind of like popping out of there because a bullet entered, and there's pressure. I don't know if you guys know about this, but when a bullet enters into a body, there's a pressure wave that goes in there. So if it enters into the head at the right point, that pressure has to go. It creates it's some kind of static pressure inside, and that has to go out. So it comes out through the eyes, through the ears. It's gross. So yeah, like his eye could like pop out or whatever. He's like, I want to cut that off. I don't want to show that to the jury. It's disturbing. It's gross. It's prejudicial. This guy's talking about like actually mitigating shit. This is the way a prosecutor is supposed to act. So far I'm liking him, and I don't like prosecutors that much.
To be able to see how close this weapon was. And by the way, that's beneficial to both sides, because it is a fact that the victim walks towards the defendant and then the defendant shoots him in the head. That is what the jury is going to be asked about here. And so I'm going to limit it. I will also state this, Judge, you know me, I will make certain the court sees all of the photos before they go before the jury.
Gentlemen.
Judge, I received a list of the photos that Attorney Huebner intends to use. So far, I'm not sure of the photo that he's referring to regarding the stippling. There is a little bit of blood depicted in two of the photographs, maybe more than a little bit, a moderate amount. I think this will have to be determined photo by photo, like day of trial during when the photos are presented. The question is, what is the value of the of that specific photograph, and what is it supposed to show other than blood? I think the state would need to assert that, and if they did, then I don't think we'd have.
Well, the state's, sorry to interrupt, the state's point is if there was stippling, I forget if it was a P or an F.
The P.
If there was stippling, the state's going to use that, I presume, to show that this was an intentional or reckless homicide because he was at close range and shot someone in the head. Is that correct, Mr. Huebner?
That's exactly what I was going to say.
Well, that's relevant. That's the definition of relevant evidence. If there's stippling on someone's forehead, that means the gun was at close range. And that's not me saying that. That's based on testimony I've heard from dozens and dozens of experts, including medical experts.
And the prosecutor's right. That's a beneficial fact for the defendant as well. I mean, the prosecutor's going to be like, look, he had the time to put the gun right to his head and pull the trigger. But at the same time, that means he's imminently close. Like if he's got a knife, he's a danger to this. He's a danger to this defendant. And if he's a danger to the defendant because he's close enough to have close range stippling on his head because that's where the bullet went in, then that the defense can use that. Absolutely. That's not a bad thing. That's not a bad thing at all.
And the medical examiner and others over the course of decades.
Well, I don't think we'll have a problem with the judge, given what Attorney Huebner stated about removing certain.
Well, why don't we just leave it at this? The state can use photos, obviously. To a degree, they have to use some photos to prove that there was a homicide. Each photo will be shown to me during the trial. If there's an argument on a specific photo, first of all, I expect both sides to play by the rules, and both sides know generally what the rules are. If there's an objection to a specific photo, I'll take it up during the trial. How's that?
That's fine, Judge.
Thank you, Judge.
All right. Mr. Ahmad, the issue of your client getting a haircut, has that been resolved?
It appears that in a couple of days he will get a haircut. He is aware of that date. We have spoken to the jail administration about that. So we'll confirm with the court that it in fact did happen when it happens.
Fine. The next motion in limine asks that the state be precluded from using language that assumes the defendant committed a crime by shooting the deceased. Such language, such as the use of the word victim, or that the defendant committed a quote crime, or that officers arrived at the crime scene is being objected to. Mr. Huebner, you want to address that? Then I'll give the defense a chance to follow up.
Well, Your Honor, first of all, I believe I would say that the officers arrived at the homicide scene, and there's no question as to whether or not this is a homicide. The question that we're going to be apparently dealing with here is whether or not it's a justified homicide. Now, I would note, Your Honor, that in terms of referring to the defendant as the defendant, he is the defendant, but referring to the deceased as the victim, Your Honor, even in what the defense is arguing, this is not like you would potentially have in some cases where there is a question as to whether or not the crime even occurred. And therefore, if no crime occurred or no incident occurred or nothing happened, then therefore there's a question as to whether or not someone's a victim. And as the court has seen some.
Okay, real quick about the haircut. The defense was asking the court to make sure their client could get a haircut because remember, this trial's coming up in just a couple days. In his mugshot, or one of his mugshots, he has a big like afro. He has a lot of hair. It's pulled back in braids right now. They don't want him looking all raggedy before the jury. So they want him to have his hair cut down, nice and probably close cropped and to look presentable before the jury. So they're asking to make sure that the jail will get a haircut for him because if he were out of jail, he would go get a haircut prior to this. So they're just asking to make sure that he's able to get that haircut. The judge does everything in his power to make sure that that happens. So now they're arguing about whether or not the dead guy can be called a victim. I'm going to disagree with the judge on this one. I think Schrader's take is the appropriate take personally, but here we go.
Some of those cases where that might be an issue. In this case, the deceased is dead. He was shot in the head. And in this case, there's not a question as to whether or not he was the victim of a homicide. It's a question as to whether or not he was the victim of a justified or unjustified homicide. So in that case, I don't believe referring to the victim as a victim in this case in any way is prohibited. The defense shows no case law to support this contention. This court has never ruled that way in any of its cases that I've been aware of. And it might be in a situation if you were talking about, I don't know, something involving.
Right. What the state's saying, and I'll hear from the defense, is this court, as the lawyers know, and as a lot of people know, presides over homicides and sexual assaults. Throw in child abuse and child pornography, and that's the entirety of my calendar. In a situation of a sexual assault, obviously there are circumstances at times where a victim or alleged victim may have made up an offense. So to be called a victim could be prejudicial. That's your argument, Mr. Huebner?
I was going to use something potentially along the lines of maybe two partners in a law office and one says one steals money and the other says, no, I was entitled to it as part of our sharing agreement. But that would be where I would say that the argument being. In this case, referring to the deceased victim as a victim, I think is appropriate. Now,
well, let me just jump in and I'll hear from the defense because.
See, and I know how the judge is going to go with this, and I don't think, I think the word victim is inherently prejudicial, and I don't think it belongs in a courtroom, personally. That's my opinion. I'm going to agree with Judge Schrader on that. Even though he allowed it in the courtroom, saying he wouldn't, but to me, that is where it just does not belong in the courtroom. You can use the name, you can use the deceased. You don't need to say victim.
Because in this case, there's no dispute, as Mr. Huebner said, that there was a homicide, and there's no dispute, correct me if I'm wrong, that your client shot Mr. Clearman. The only question in this case is going to be, was it a homicide or was it self-defense?
Judge, that's true, but also I think the court can consider, if you want to look at alleged crimes, one could argue that alleged crimes were committed by the Clearmans as well, in terms of reckless endangering safety or going armed with a weapon, disorderly conduct, things of that nature. So that's another basis for our request, is if they're going to use those terms, then I think it would be fair game for the defense.
Further, Your Honor, we also want to bring attention to Wisconsin Jury Instruction 805, which discusses self-defense, and it allows such actions, which we believe Mr. Edgecomb's actions would fall in, if he reasonably believed that such force was necessary to prevent an imminent death or great bodily harm to himself. Secondly, we also want to bring to the court's attention to note that Mr. Edgecomb enjoys the presumption of innocence. We believe that no one is a victim in this case until it is proven in a court of law. That simply has not occurred at this juncture. As the court has reiterated on several occasions, this case is not to be litigated at this point. And while the facts and circumstances in this case are very unfortunate, our heart does go out to the Clearman family, but Mr. Edgecomb, through such presumption of innocence, is as much as a victim as anyone else. The term victim crime scene is prejudicial. It would tend to be heavily influential by a jury who would likely presuppose which people have been wronged in this case. We would further caution that the court's usage of the term victim in open court or during jury instructions would tend to further violate due process because it's suggestive that the issue is resolved against the defendant before the jury gets to decide this issue. Finally, Your Honor, there's so many different synonyms that the state could use in place of victim. They just refer to Mr. Clearman as the decedent. He can definitely do the same at trial. And for those reasons, Your Honor, we would ask the court restrict the usage of these terms.
Mr. Huebner.
Your Honor, the Wisconsin jury instruction for homicide, if the court, and the court knows this, it states the defendant did cause the death of, and then in the jury instruction it says, insert name of victim. This is a homicide. He's a victim.
Right. Let me jump in. It's a homicide. He's a victim. Whether he was the victim of a self-defense situation or he was the victim of a reckless homicide is what the jury is to determine. And I know where this is coming from. I read the news. This is not the Rittenhouse case. I know Judge Schrader. I consider Judge Schrader a friend of mine. I have never required the state or told the state how to refer to somebody when they're on the stand. Now, if the state uses the word victim 752 times, I'll probably tell them to back off because they'll be belaboring it. But I'm not going to tell the state how to try their case. And there was a victim in this case. There's not a dispute, as the state said, over a contract dispute amongst lawyers. It's not a sexual assault case where maybe the victim or alleged victim is making up an allegation. In this case, the state has their belief, and there was someone who was a victim of this homicide. There was a homicide. As the defense just conceded, the only question is, was it what the state charged the defendant with, or was it self-defense? And at some point, I guess we're going to come back to the information at some point if we're doing that today or another day, Mr. Huebner. But so that's my ruling. I'm going to ask the state to draft an order after the case is over for today, based on my rulings on these motions in limine and the expert testimony. The next motion has to do with the testimony of a witness, a person who says, and this was filed on December 28th.
Just a real quick refresher. The state gets to, oh, hey, here we go. Welcome, sir. Oh, look at that.
Hola.
You are inferior now. How's it going, man?
Pretty good. Pretty good.
So
sorry, I was late seeing your note, but I was out in the garage working on the motorcycle, and but I'm here now. Hence, no tie. No tie when working on the motorcycle.
That's fine. We've just I'm about 30 minutes into the pretrial hearing. I can catch you up on. Did you check out this pretrial hearing? Have you watched it already?
I saw like a news media coverage of it, so they just had little snippets of it. I presume what you're talking about is like the entirety of the hearing.
Yeah, I've got it's an hour and a half, 35
I've not
minutes
seen
in.
that.
Okay, well, I can summarize what's happened so far. The defense has lost their use of force expert. He is not allowed to testify at present. They can beg the judge to allow him to testify, but they were going to have him testify about the use of force continuum, which is weird because this isn't an LEO. It's a civilian who does not have law enforcement training. And they wanted him to testify to the apparently subjective reasonableness of the defendant's actions. Which the judge is like, no, you cannot have someone testify that he believed his actions were reasonable. He would have to testify to that, which makes sense.
I hold on a second.
Yeah. Everybody lip read what he's saying.
Sorry, little office supply crisis. We're out of paper, apparently.
I know how that goes.
Yeah, I got two little girls in the house who constantly steal all the paper for their art projects, and now we're out. It turns out there was a finite supply. I mean, I buy it by the box.
Yeah,
but
you're singing my song right now. Real
but
quick.
anyway, so I think Jesus, what the hell was I going to say? So in terms of the force continuum, what normally when people say that, what they probably really mean, and I think this will be a key issue in the case, is actually that what I call the element of proportionality, that the amount of force used was proportional to the threat. I think that's going to be a major issue in this case because I believe the victim, we can call him a victim, I guess, in this trial, the attorney who was killed. It's hard to see how he was presenting as a deadly force threat when he got shot in the face, which is going to be a trouble for the self-defense claim. So I guess that's what they need to be able to argue, that element. They found some paper, and they, of course, it's less important if it's true, really, and more important if it was reasonably perceived to be proportional by the defender. So I guess that's what they wanted their expert to say. It's like, look, facing these circumstances, facing a white immigration attorney, anybody would perceive that as a deadly force threat against which deadly defensive force would be justified. And of course, the judges rightly resistant to that because it's mind reading.
Yeah.
If the defendant wants to take the stand and testify he had that subjective belief, that would be fine. Or if there was evidence from which a jury could infer that, that's, I don't know. Maybe if
Yeah,
he was
now
running away.
The allegation is that the attorney did have a knife and yelled a death threat of some sort. I'm going to kill you, N-word, is the allegation, but the only witness to that is the defendant.
Was
of
there a
course,
knife
so.
recovered?
I've seen a picture of a knife on Twitter presented by the defense. I have not seen evidence that the knife was recovered yet. It might be. I haven't seen that, so I can't say whether or not it was. But if the guy did have a knife, I mean, that changes, that puts it more likely to be self-defense. The other thing they argued over was there was a motion in limine from the defense to restrict the state's ability to use video. So you've seen the video, right? Of the bike.
I've seen a couple little clips of video, and what I saw wasn't particularly decisive. I mean, I did see it looked like the defendant was on a bicycle, right?
Yep.
And he was basically moving away from the victim, and the victim got out of his car, passenger in the car. I think his wife is driving, and foot pursued the defendant, which is not a good look. Not necessarily a deadly force threat, of course, which will be the question here, but he went to the fight rather than the fight coming to him. But of course, he's not on trial, so he's
Right.
dead. But it doesn't, that's favorable to the defense. But there was other video too. Somebody struck somebody through the car window. I guess it's claimed that the defendant struck the lawyer through, but then the defense is claiming, well, the lawyer did something first to, I don't know, provoke that strike through the window, and
right.
That's about my understanding. But I have to say, I have not yet seen what I would call really clear, definitive video of any of these events.
Yeah, the video of the punch has not been publicly released as of yet. However, the defense moved to exclude it. They went back into chambers and reviewed the video. State attorney says, well, let's go in chambers and review it. That way, if you deny it, it's not out there for the media to consume. And so they go back in chambers and they come out, and judge is like, yeah, this is definitely going in. This is probative. The argument from the defense was, well, there should be a video of the incident preceding the punch that would show it, but the state hasn't found it. So we think the other video shouldn't come in because the state hasn't found the prior video, which is not the greatest argument.
Well, I guess hold on one sec.
Yeah.
I got people unwrapping mail packages right outside my door. What next? A big bag of potato chips, just
yes. Yeah. Dad, we're gonna play marbles.
But I guess, if that video, the punching video, is not going to be a good look for the defense. And of course, they would prefer it not come in. And if they don't have a real reason, then you make up a reason. And this is the made up reason. I mean, you argue what you can on behalf of your client. I get it. It's just not a compelling argument. It's all you have to work with.
Well, that was their problem with the use of force expert. Because you mentioned your argument sounds good. They're going to argue proportionality. The problem is, apparently in their written briefing and in their argument today, they didn't rebut the state suggesting that they're using a law enforcement officer's use of force continuum. Their use of force expert is a homicide detective, and I'm not sure what his use of force qualifications are at all. But yeah, the judge basically said, no, he's not going to testify to the use of force continuum. This guy is not a trained law enforcement officer, and he would have no knowledge of that continuum at all. The jury is charged with finding out whether his actions were reasonable or not.
So unfortunately, I mean, this is just an opportunity to remind people that even a lot of legal professionals don't really know use of force law at all. They just kind of fumble their way through the process. And it's like the difference between listening to someone who, is a concert level pianist play the piano and listening to a 3-year-old banging on the keys. Technically, they're both playing the piano, but only one of them is something you'd want to listen to. A lot of lawyers are going to come up with these use of force law arguments that don't really make sense if you actually understand the underlying legal principles. But that's their very imperfect understanding of the law. And So they make these very imperfect arguments. And that can happen with your defense attorney too, folks. If you hire a defense attorney who's typical on the subject matter as opposed to genuinely expert, and they'll fumble your way right into prison.
Yep. And so that's the basic gist of it. The prosecutor talked about photos. The defense was concerned about photos, although they didn't have specific concerns, but obviously they don't want 4 million pictures of the bodies being shown. Prosecutor said he's limiting
I think it was
his
shot in the face, right? So that's gonna look terrible.
The prosecutor addressed that actually. This prosecutor is shocking so far. He basically said, he does want to show one picture of the head because there's stippling, and he wants to show it. And he's like, that actually kind of helps the defense too. It's a good fact for them that he's that close. But he said there is a part of the picture that shows the eye in a disturbing way. I imagine hydrostatic pressure.
Yeah, right.
Maybe popped it out. So he said, I want to either cover that up and obscure it, or just cut that out entirely and only show the stippling and the bullet wound. So he's cognizant of how that looks. No pre-cleanup autopsy photos, only post cleanup. So no just giant bloody messes, and really only, he said, only, a couple pictures of the victim at all. A tiny amount of body cam footage that will have some blood, but it sounds like he's very aware of how this judge, by the way, his entire docket is murder, sexual assault, and child pornography. That's it. That's all he does.
Well, it's gonna be hard to fool him.
Yeah, and he's and this prosecutor has practiced. This is Milwaukee, so he's probably done several murder cases in front of him, and he seems very aware of how the judge deals with that type of stuff. And so he was already ready to limit it. Defense seemed fine with that, and then now they're talking about the victim, or no, they're going to be able to use the word victim in this courtroom. He says he is a victim, and I want to say to the chat, homicide does not mean murder. A homicide is a man-caused death, a human-caused death. So a self-defense homicide is still a homicide, same way that a murder is still a homicide. The self-defense and the murder are the legal distinctions about the homicide. So when the judge says it's a homicide or it's self-defense, he's not actually confusing those two terms. The self-defense killing is a homicide. In the same way. So
it always drives me crazy. Often when some new gun laws pass or a state becomes a stand your ground state, 6 months later, all the newspapers will publish stories about how the homicide rate's gone up, as if that's a bad thing. I mean, whether a homicide is a good thing or a bad thing depends on who's doing the dying.
Right.
If law-abiding people are defending themselves against rapists and murderers, and that's resulting in the death of the rapist or the murderer, that's a homicide. Homicide just went up, but that's a social good outcome.
Based and red-pilled. Murderers dying is great. Yes, I agree. Actually, it is good.
Relative to the alternative.
Right. So here we go. We can just rope right back in.
This individual came into contact with the defense attorneys, I'm paraphrasing, after the final pretrial hearing, specifically on December 22nd. This person allegedly saw news coverage of the pretrial hearing, which was on the 21st, and came forth allegedly with additional information. And the state's asking to introduce this woman's testimony.
Not the state.
Sorry, the defense is asking to introduce reputation evidence and evidence of conduct, instances of conduct, and other acts evidence. Basically, that allegedly Mr. Clearman
is a racist.
He's a hothead.
I mean, for the defense, it's pretty inflammatory language.
Oh yeah, racist.
Judge, I don't have to repeat it, but the motion states what that language is, and it's relevant in this case because that's what, when Mr. Edgecomb testifies, that was the same language that he had heard. So I've provided the state with the police or the accident report involving, basically, Ms. Burton has documents to prove that she had a previous motor vehicle accident with Mr. Clearman, and during that encounter, she observed certain behaviors. In addition to that, she had known him from several different establishments on the
How many
east
defense
side.
attorneys are there?
And
Just this one guy, or is there more than
to
one?
observe him, so she can testify as to his
2 so far. The other guy should be right next to him here, but he's off frame for whatever reason. Yeah, so they're trying to introduce evidence that this guy's a raging racist. That's what they want to do.
Reputation and her opinion about some of his general characteristics. As to the specific act in October of 2018 involving a car collision, she stated that Mr. Clearman was aggressive and hostile with her. He showed road rage. So that doesn't, I don't think, come under specific instances of conduct, because that would have to be McMorris evidence, but it could be introduced as other acts evidence, and we're offering it.
Wait, the specific evidence of road rage on a specific date isn't a specific incident? Like, what are you talking about? Well, on October 28th of this year, he was done in this specific thing, but that's not a specific act. That's something else. Nonsense.
I mean, maybe they could argue for, if they can get someone to come in and talk about reputation, maybe. This specific act stuff is so prejudicial, because for all we know, the guy was having one bad day.
Right. Well, 2 bad days.
Well, yeah.
Because on the second one, he died.
One worse than the other.
Yeah.
Just the general MO of Mr. Clearman.
Well, that's
in
general MO.
crimes.
That's not MO. That's just character evidence.
This was similar to that. These 2 acts are similar in nature in terms of he had some sort of road rage incident with Miss Burton involving alcohol, involving certain belligerent language, inflammatory language as well, and then apparently there were some racial slurs. His wife was also present at the time. I provided counsel with photographs even from that day. She also could testify as to his habit and routine as far as what she had observed and how many times she had seen him in bars. The state's already preemptively filed their own character witnesses, which, if this evidence is introduced, then they could offer that in a rebuttal. But the state's already provided a list in case the defense seeks to do that. And we do have a witness that came forward based on her viewing things in the media. And we know that's a fact because we have the police reports of everything, in which I've turned over to counsel.
So Hubner.
Well, first of all, Your Honor, to begin with, the character evidence that the defense is attempting to bring in can only be brought in through reputation and opinion. I do not believe that the defense can establish reputation and opinion evidence. And that is because by their own submissions to what they've provided to me, this witness does not go to any of these places anymore. So whatever this reputation or opinion may have been in 2018, and I think it's highly suspect, especially considering some of the allegations that this witness has made, and I'd prefer to refer to them not on the record right now. If we need to, we can talk about it, but they're outlandish claims.
Right. I'm specifically not using the terms because, gentlemen, they're outlandish allegations. Maybe they're true, but the allegations are using incredible slurs, about the worst slur you could use against an African-American and the worst slur, or one of the worst you could use against a Latino. And I'm supposed to believe that Mr. Clearman was doing this routinely all the time in front of witnesses at bars, like left and right, including about his wife. I mean, Mr. Mott, that's a very tall climb. You want me to believe that this witness that showed up on the scene a day after what was supposed to be our last hearing and now has incredibly vile, spurious allegations using 2 of the worst words you can use, 2 of the biggest pejoratives you can use against a Latino or an African-American, and that Mr. Clearman was doing this like left and right every day, all the time. That's a lot. Hang on, the state still has the floor. That's a lot for the court to swallow.
I would also note, Your Honor, that
that's a hard no.
So that's that portion. I don't believe that the defense has provided that this witness is in fact a member of the community that would know the reputation of this, of the victim in this case. They talk about the fact, as a matter of fact, she talks about the fact she stopped going to these bars according to her own claim, she's not even in a situation to know the reputation of the witness. That is why I don't think that should be allowed in, at least as it stands right now. Maybe the defense can have some more. What I am concerned specifically about is,
can you imagine how like lit those bars must be where this immigration attorney is just like presumably standing on the bar, just like singing the N-word while waving his giant Confederate flag around? We're supposed to believe this. Like, this is a nonsense claim.
I have to wonder also how many immigration attorneys turn out to be wild racists. I mean, that would seem like an odd career choice for
yeah.
for a racist.
Yeah, it just, I mean, it's possible, certainly, but it just doesn't seem likely. It seems like maybe that's why he's at the bar all the time. He's like, I hate my job. I'm letting all these N-words into the country. It's like, what are you, what? We're supposed to believe this? This is nuts.
and more so than anything else, is their attempts to bring in specific instances of conduct through this witness. And first of all, the defense needs to understand that reputation doesn't allow you to sit there and say that this person has a reputation because I saw him do this, and this. That's not reputation evidence.
Yep.
That specific instance, that's prohibited. So almost all of the things that the defense has put in there is this woman speaking to alleged specific instances which are not allowed. And they would not be allowed until unless the state then introduces its own reputation and an opinion evidence, which we've noticed. And obviously then if we do so, this could be revisited. But in their case in chief, to sit here and say, well, I saw him do this one time, and I saw him do this one time, and this is how he refers to people, that specific instance, under Wisconsin state statute, that is not allowed. Reputation and opinion are very small areas in which she can just sit there and say he has a reputation for that. But even within their own, what they're talking about, it's not current. It's supposedly 4 years ago. And additionally, and I think this is important, by someone who makes outlandish claims as to what she thought actually really happened during this homicide, and also was involved in an automobile accident with the victim. That again, and then getting to the specific instance that they're attempting to bring in as other acts of modus operandi. It's not, there was supposedly a vehicle collision between these two. Actually, there was, we have the reports on it, but nobody got shot. Nobody got punched. Nobody got attacked. How does that have any relevance to this situation in which, in this case, it wasn't the defendant driving, or sorry, it wasn't the victim driving. The defendant punched the victim, and then the victim follows him and is shot in the face. It has no relevance whatsoever to this incident. And that is why that prior altercation should not be allowed in. If they can establish reputation and opinion, which I don't think they can at this point, then that's fine, and that can be that limited testimony. But all of these horrendous allegations, some of which defy logic, I don't think should be allowed in because they are, again, specific instances and they're not reputation and opinion.
Okay, Judge.
All right, I'll hear from the defense on the two issues, the specific instances of conduct as opposed to reputation and opinion. But go ahead.
Judge, first, of course, the court can voir dire this witness and we can ask in more detail about how well she knows Mr. Clearman. From what I understood from her, she's known him for over 20 years, and she knew him in the bar community. She described him as a bar fly. So some of the places that she frequented where she would know him and see him was Why Not Tavern, Coffee Tales, etc. That's part of the habit and routine practice, as well as going to his reputation within that community and her opinion of him as far as her observations.
Well, he goes to bars and
trying.
restaurants. He goes to bars and restaurants. Therefore, he has a habit of being a racist. He just
of doing stuff that deserves getting shot in the face.
Yeah,
so
you're right.
This reputation evidence, folks, it's not any part of your reputation. It would have to be relevant to the actual legal elements of whatever the crime is or whatever justification is being claimed for that criminal charge. And going to bars and restaurants is not one of those.
If they're going to make a habit argument here, theoretically, they would have to make a habit argument that he's prone to getting out of cars and chasing down minorities and yelling racial slurs at them or something, or aggressively running after people on bikes, for example. He hates bikes, stupid bikes. He's an attorney elitist, and he doesn't think that anything without an engine should be on a road, for example.
Well, that's plainly true, but
I mean, that is true, but yes. But they
but
would have
even
to
more.
show
I mean,
that-
I would require more than that. I would require, so he got in an accident with this woman, a car accident, and then he punched her in the face, or he threatened her with deadly harm. I mean, then it begins to look probative to
but
this particular case.
begins to, because that's still a specific act of conduct.
Yeah,
That's
right.
what she's supposed to testify to is actually not her own necessarily her own experiences with him. She's supposed to testify that the community's experiences with him are consistent in this particular way, that anybody in this community basically would know who this guy is. They would know he's out yelling the N-word at people and talking about the gardeners. I assume that's the derogatory slur for Hispanic people that he's talking about. That they would have to have something like that on here. And so far the defense has not given anything. Michael Hickson says, Bronca, self-defense course was epic. Thank you very much. Worth every penny.
Well, I appreciate that. Best way to say thank you, of course, is to tell the rest of the world as well. You've done that here in the comments with everyone here, so I much appreciate it. That, by the way, I don't know if Binger and Krause attended. If they did, they didn't use their actual names. But Zoom gives people the option when they sign into the course to give just say anonymous. And we had quite a few people who do that. It's not uncommon because people want to be able to chat and ask questions and not necessarily reveal their identity in the process. So they may have been on. I don't know if I could look by IP address or something like that. But if they were on, because I checked the registration list. There was no Binger and no Krause listed by name.
Kingslayer, everything I've heard about it, I haven't gotten a chance to watch it yet, but I do intend to watch the replay. But everything I've heard about it was great. Like everybody praising it. So that's good news, I guess.
Always nice to hear. Yes.
Of course, there is a problem with saying that the people love it. You know what that problem is, right?
No.
Here, let me tell you.
But the people are retarded.
Kingslayer Damocles says, how can you be a victim of self-defense? Doesn't a victim of self-defense literally just mean attacker? Also, cry more about having to do your job more, judge. When I've got to read motions, I bet this judge has a clerk do half of it.
He definitely gives off a man, this is tiresome vibe. Like he doesn't want to be there. It's very, very funny. So the reason judges do this is when we cover this stuff, like in law school or you read appellate court decisions, they almost invariably refer to the person who was the target of the force that's claimed to be self-defense. They almost invariably refer to them as the victim, meaning the victim of that use of force, not the victim in the sense that the force was necessarily unlawful. They're speaking in a very, technical term of art kind of way when they're using the word victim there. Of course, our colloquial, common English use of the word victim suggests that something wrong was done to that person. That's what makes them a victim. But in legal talk, legal conversation and analysis, it's very common, even when the person who was killed in lawful self-defense, to still refer to them as the victim of that use of force. And so because that's how lawyers are, to the extent they're taught this stuff or read case law on use of force instances, that's what they read. And therefore they tend to repeat that. And of course, judges come from lawyers. And so they tend to have the same pattern. It's relatively rare to come across a Judge Schroeder who kind of recognizes the prejudicial nature of that word in the ears of jurors, as opposed to in the ears of lawyers and other judges, and won't allow it in his courtroom. That's relatively unusual.
I will take the position that I think the appropriate answer is to never allow the word victim to be used.
Yeah, I concur.
I think Schrader's right on that, even though he did ultimately allow it. And Mark Richards used it in his opening statement. So there's a big fuss over nothing. But I think that's the appropriate way to do it. I think there's too much prejudice in the word for no discernible worth. And then finally, Barron's guy says, Nick, please teach Bronca how to save super chats without scrolling. Also, after my mom had breast cancer, she was self-conscious of her body. Hook Andrew up with British Phil's number since he does great breast construction. Oh, stop it.
You do need to show me how to do that super chat thing, because the way I do it scrolling through, it's extremely tiresome.
I'll teach you all the ways.
All right.
The ways of the grift. Okay, here we go. Back to this.
Specific instance from October.
Okay, hang on. So she's known the guy for 20 years, and yet she didn't come upon this alleged information until after this case has been litigated for 6 or 7 months, after multiple news conferences, some that have been held by the defense, some statements by the victim's family. She, lo and behold, came across all this on December 22nd, way after a year after this was originally charged, way after a year after this incident, and after your client's been in custody for 6 or 7 months, on literally the eve of the trial. She stumbled across this.
It wasn't the eve, it was the 21st or 22nd, Judge. And
right,
yes,
but
we
intervening in those 10 days was Christmas, New Year's, and 2 weekends.
Judge, she's an elderly lady. She's probably in her 60s. That was the first time we've ever heard of her. I had no knowledge of Miss Burton, but she had provided us with reports about it.
Mr. Ahmad, first of all, 60s is not elderly. Someone who's getting dangerously close to 60, that's not used to gardens like that.
I apologize, John. I didn't mean it that way. I'm just saying she was unknown to our office or to Attorney Lamar. I have never met or heard of Miss Burton. She had come forward after she had seen the video in this case, which was recently released and was not known to the public. But after coverage in this case, there was significant coverage on the 21st. She happened to see that and called her office the next day. And that's been, from that point on, the only contact we've had of her. I think that for more clarity, you certainly could voir dire Miss Burton as to more details as to how she knows him and the reputation. I think the standard is not as high as what the state's saying here. If she viewed him in a bar where he was intoxicated, then I think that these so-called outlandish claims are not that outlandish.
Wait, what?
Wait a minute, but that would be a specific instance. You can't bring in specific instance.
Yep.
You have to bring in reputation or opinion.
Right, I agree with that. And so I'm not going to make a blanket ruling today regarding Ms. Burton, Burton. If it comes to that during the trial, if there's a possibility at some point of the defense introducing reputation and opinion evidence regarding Mr. Clearman, not specific instances, we can voir dire, or I will voir dire the witness with the assistance of the lawyers outside the presence of the jury. It's a little hard for me to rule on this exact evidence because I don't know exactly what she would testify to, though there is basically an offer of proof in the defense motion. So I'm not barring Ms. Burton, but before she were to take the stand, she would have to be voir dire
my dead body
and the attorneys, and she may be allowed to testify. She may be allowed to testify on certain topics only, or she may not be allowed to testify, depending on what I hear. So that's my ruling on her situation. That brings us to the motions limine that were filed on December 31st. The first one's regarding testimony from Detective Fraley, F-R-A-L-E-Y, or Ruby, R-U-B-I-E, Mizell, M-I-Z-E-L-L. There's also testimony potentially from a Detective Kirkvold, K-I-R-K-V-O-L-D, testimony from a Kentucky State Trooper, and others. Since the defense filed and I read it, I'll hear from the state first, specifically as to what might be introduced by Detective Fraley, Detective Kirkvold, or others.
Okay, so let me get to the first portion, which is sub A, which is Guy Fraley and Miss Mizzle. I don't plan to introduce any of that. Whether or not there was any allegations of domestic abuse towards Miss Mizzle, I would not do so in my case in chief, except, and this would be the only possible way it could come in.
Okay, real quick. Motions in limine are a motion requesting the exclusion of evidence at trial. And they want to deal with it pre-trial because they don't want to have to wait until it possibly comes up, prejudices the jury just by the nature of the question or the nature of the discussion of the witness. They can handle it pre-trial. The issue here for the defendant is that he has a significant criminal record. It is non-felony. However, it does involve violent misdemeanors and misdemeanor gun crimes, and those misdemeanor gun crimes and potential domestic abuse issues coming in could be prejudicial. So his allegations about domestic abuse, he was actually charged with felony domestic abuse, but it was dismissed when the witness refused to testify against him, the witness being his alleged victim. So that's the stuff this attorney is saying he's not intending to bring that up. However, it may come in if the defense opens the door and he's trying to make sure that he's prepared for that. So that's what seems to be going on here.
That's if there is not a stipulation to the fact that the defendant was out on bail, because this allegation, first of all, there was a charged case involving domestic violence as well as, involving domestic violence. That is when the defendant was out on bail for that case with a no weapons order and then didn't come to court. That's what's going on. So if there is in fact a stipulation to the fact that the defendant was out on bail, then I do not need to prove the fact that he had an open felony case with the condition that he not have a weapon. That would be the only way. I don't see anything in that unless someone calls Miss Mizzle, and then that would be something that maybe we would have to deal with outside the presence of the jury. But I can tell you that I do not envision attempting to introduce this prior domestic violence incident as to having any relevance, except for in that it may affect Ms. Mizzle's testimony, but I don't see that being a factor here, especially if there is a stipulation. Now, I have drafted that stipulation pursuant to Old Chief, in which the defense, if they do want me to enter into that stipulation, can prevent me from letting the jury know the nature of all the underlying charges. It would be he was just out on one felony bail, he was out on one misdemeanor bail, he had the condition, he knew about that, and that's it. And then we'd be done. And then everything that they're talking about in regards to sub 1 and sub A, I don't see how it comes in.
All right, well, before we get to the rest of it, the Kentucky officer and Detective Kirkbold, what's the status on that, gentlemen? Everything Mr. Huebner just raised?
Regarding the stipulation, I think that's something that we could deal with on the day of trial, Judge. It was something that I was also wanting to discuss in chambers.
Why not just stipulate now or say, no, we're not comfortable with the stipulation?
All right, we can potentially do that in a minute. All
right.
But let's talk about Detective Kirkbold and the Kentucky State.
He said we can potentially do that in a minute. He does not really want to wait for this stipulation till the day of trial. That doesn't make any sense. Because you know what they're going to do. They're not going to stipulate at the day of trial, and it's going to cause delay.
Right.
Just nonsense.
Patrol officer.
Your Honor, first of all, regarding the nature and circumstances of the traffic stop, I don't plan to be getting into that. What was found inside the defendant's vehicle, I don't plan to be getting into that, other than when they do a search of the vehicle, they find his ID card, which is how they know that he lied to them. And Your Honor, you have already ruled, pursuant to consciousness of guilt evidence, that when the defendant flees the state, that's consciousness of guilt. I included in my motion this very conduct, that when the defendant, and we talked about it a lot at the last hearing, and the court ruled within parameters it can come in. When the defendant is stopped, by the way, and I think this is very clear, he's stopped in a vehicle, a rented vehicle, that is rented by Ruby Mizzle, who he had no contact order with, but it's rented by her. He states that he is going from Texas to Kentucky. That's not true. And he also, when asked for a name, says he does not have identification and provides a false name and states that he was licensed outside the country in the Bahamas. All of that, Your Honor, I think is clear consciousness of guilt information because the defendant is attempting to avoid being captured for this homicide. And that is important, as the court has already ruled. Consciousness of guilt evidence is important for the jury to determine whether or not the defendant is being sincere in regarding his claims of self-defense. The fact, as the court has said, had the defendant stayed on scene, called 911, done all of those things, that'd be one thing that the state would have to deal with, and the defense would be making a big hay out of that, and I would have no argument to keep that out. The same is, the reverse is the same here. This defendant left the scene, then he left the city, then he left the state, and when someone pulled him
Very
over,
dramatic.
he lied about his name. Lying about his name. I'm not going to make a big deal out of it, but at least the fact that he lied about his name and claimed that he was from another country is relevant for this jury to understand that he did not, in fact, believe he was operating in self-defense. He was trying to get away with it.
So have you talked about what consciousness of guilt evidence is, Nick?
No, I would love it if you would do that.
Yeah, so unfortunately, a lot of the advice people give each other about use of force offense is advice that really qualifies as consciousness of guilt evidence. Things like if you shoot somebody outside your house, make sure you drag him inside the house before you call the police. Consciousness of guilt evidence is essentially just recognizing that it's a basic human behavioral characteristic that people who believe they're guilty of doing something wrong tend to conduct themselves differently in observable ways than someone who doesn't believe they've done something wrong. And in a use of force case, it typically involves conduct like lying to the police, tampering with evidence or tampering with the scene, attempting to get witnesses to change their testimony, flight from the scene for purposes other than safety. So you're always allowed to flee the scene for purposes of safety. If you're in a dangerous place, you don't have to stay in a dangerous place. But once you've achieved a position of safety, the normal rules apply again. And what this guy did was a bunch of that stuff, right? He fled way further than necessary for safety. Then when he did encounter law enforcement, he lied substantively about who he was and where he was from and where he was going to avoid being held responsible for this particular event. And what can happen then if the judge approves it, and it sounds like he has, is the jury can actually be read a consciousness of guilt jury instruction that basically tells them, hey, the prosecution has accused the defendant of certain conduct, flight from the scene to avoid accountability, lying to the police, and so forth. If you believe that's been proven beyond a reasonable doubt, you are allowed to infer that apparently not only does the state believe the defendant's guilty, but the defendant believes the defendant is guilty. That's a bad jury instruction, folks. Plus, all that conduct, fundamentally, a use of force claim is based on your credibility as the defendant. You know, the jury wants to believe that if you've killed someone, that had to happen. There really was necessity there. And if you're lying about it, you have no credibility. If they believe you're lying about it, you have no credibility. And if you have no credibility, why should they believe anything about your narrative of self-defense? It goes right out the window. So the defense is going to fight. I presume it sounds like they've already had this fight, really, but they're doing it again to try to get this consciousness of guilt stuff thrown out because it's extremely damaging.
All I want to know, or all I want to see, is the dash cam footage of the Kentucky car stop where he claims he's from the Bahamas, because I want to hear the fake accent. I
This
just
is
want to hear him.
Bahama country.
Yeah, man. No, I headed down from Oklahoma, man, down to Texas, man. You know, I want to hear it. I want to hear the island accent come through. I want to hear him put it on. That would be great.
And what are the odds the car was loaded with weed? I mean, that's the stuff the state is like, hey, I don't even want to talk about what they found in the car, you know?
Yeah.
I'll tell you what they found in the car was a bunch of weed.
Here we go.
So, Judge, the court's already noted previously at the last hearing that there may be another reason for his flight, which is what the defense intends to put on at trial. There was another reason for his flight, which we know what that is. It pertains to the other bail jumping charges. In this case, I know counsel told me he already agreed.
He wasn't fleeing the self-defense shooting. He was fleeing his other bail jumping charges. Okay. All right, buddy. Sure.
Agreed that we're not going to get, well, that's also pertaining to the same incident with the trooper and Detective Kirkvold. That is letter C. As far as, what is the scope?
Did you hear that, Andrew?
I heard that so one of the counter arguments you can make to consciousness of guilt argument by the state is that no, I wasn't fleeing to avoid accountability. I had some other reason to flee, and sometimes there is a reason. Sometimes it was a gang event, and the other gang will hunt you down if you stay in the community, stuff like that.
Right.
You should still call the cops, but in theory, there could be. And a lot of judges don't like consciousness of guilt evidence, especially flight evidence, because they do say, listen, nobody wants to get arrested, right? Even if they don't think they did anything wrong. So a lot of judges won't allow it for that purpose because they think it's too prejudicial. But when your excuse is you weren't trying to avoid accountability for this criminal offense, you were trying to avoid accountability for a different criminal offense, I'm not sure how compelling an argument that is.
It's very self-serving and also hilarious. Here we go.
This is what we had mentioned at the previous pretrial hearing, is how detailed are we going to get into this after the fact conduct? How probative is that? How much time is the state going to spend on everything that transpired after? Because none of this stuff relates to the 24 seconds we see in the video before the shooting. I think the parameters got to be narrowed here. We're talking about some of these small little details. At some point, it's just going to become very cumulative.
Well, as far as that testimony, I mean, yes, I ruled that the consciousness, the flight, concealment, consciousness of guilt evidence can come in. It's pretty black letter law. There's a jury instruction that specifically discusses the impact or lack of impact of, again, flight, concealment, consciousness of guilt. I'll allow the state to talk about it, but in brief form, the state's not going to belabor it. We're not going to get into all the circumstances of the arrest or what led up to the arrest, but the fact that the defendant was apparently apprehended by all accounts in Kentucky, that he allegedly may have had a false information or not had an identification or given a false name, that's relevant to the state's attempt to prove that this was a homicide. It's relevant to consciousness of guilt. Again, because I said this at the last hearing, but as Mr. Huebner was just referencing, in a case that I tried within the last 6 months, a self-defense case, that was the opposite. All the other evidence came in. That evidence happened to be helpful for the defense, but in that case, the defendant stayed on the scene, called 911, applied pressure to the wound, turned himself in, and made an immediate statement that this was self-defense. In this case, your client fled, apparently, left the state, went 5 or 6 states away, was on the lam for 6 months, and then told the police he was a different person when he was apprehended. That's also relevant. It cuts both ways.
Can you pause it a second?
Anything else we need?
So, folks, this is really, when we teach our class, we spend about an hour on interacting with the police in the aftermath of a use of force event. And a lot of people will tell you, don't say anything to the police. 99.9% of defense attorneys will tell you, for God's sakes, don't talk to the police. And it's hard to go wrong with that approach. But our position has always been it's worth at least considering the possibility of having a very few, very specific things you might say to responding officers or 911. And nothing but that. So certainly not blathering, but things like saying at the scene, I had to act in self-defense. That's extremely helpful because if you don't say that, if it's only said, days or weeks later, it begins to look, you have to remember that most claims of self-defense are bullshit. They're nonsense. They're fabrications by bad guys who are trying to avoid legal accountability. And if the first time you said self-defense was, after you've talked with a lawyer and thought about it for a couple of weeks, it looks like all those other fabrications. That's how they all look too. So if you want to differentiate yourself from the typical bad guy case of self-defense, and you do, saying at least it was an act of self-defense, I had to defend myself right at the scene is helpful. Just like it's helpful in this case that this judge is referring to here.
Yeah, and I just want to say it. So far, you don't want to look like Theodore Edgecomb in your self-defense case. He may ultimately be not guilty, but right now he looks really guilty. And I'm typically deferential to the defendant, but this guy looks really guilty right now. And it looks like they're trying to pull a bunch of tricks to get him off. This looks like the bad guy self-defense claim comes like, oh, there was a knife that shows up in evidence later. This guy runs and is gone for 6 months. I mean, if the knife came later and wasn't found by police, and I guess we'll find out, then there's real questions as to whether the knife ever existed, right?
Yeah,
If the
I mean, if it
defendant's
has the victim's DNA on it, and if you carry a knife on your person, if you carry a knife on your person in your pocket habitually, it's going to have your DNA all over it. It'll have skin dander and stuff all over it. It's clearly not something that was dropped by somebody else.
Yeah. Here we go.
Need to address today, gentlemen. And by the way, unless it's an emergency, I don't want any more motions filed in this. The trial starts next week. I don't want to see a new motion come in every single day between now and next Tuesday, unless it's an emergency that I need to deal with, and I'll deal with it on the day of trial. That goes to both sides.
Yes, Your Honor. The only other thing, Your Honor, that I think should be addressed is the next portion, which is sub C of their motions in limine. And this is the situation, and I just want to be very clear because the motion in limine has some facts, and I want to explain it. And if necessary, again, I'm willing to play this small portion. It's about 30 seconds of an audio tape for the jury in chambers, just in case the court rules that it can't come in. But what happens is detectives go down to speak to the defendant. Prior to reading him his rights, they're asking him the questions the court knows that they ask. Are you on medication? Are you drunk? Do you understand what we're talking? All the various questions detectives ask for one purpose and one purpose only, which is to make certain that the guy understands his rights and understands what they're talking about, so that prior to reading him his rights, and if he waives those rights, they know he understands his rights and they're reading them. And if they just walked in, read him his rights, and the guy said yes, then the defense would be all up in arms saying, well, you didn't make certain that he understood English. So in this situation, they're asking him those questions. The defendant says, well, I want to know what you're here for, or words to that effect. The detectives, after making certain...
The defendant says to the officers, what?
Detectives. Basically words to the effect of, well, I want to know who you are and why you're here. So the detectives then identify themselves as Milwaukee police detectives and state, we want to talk to you about what happened in Milwaukee. And as the defense puts in their brief, he responds, what happened in Milwaukee? Now, I want to be very clear about this. The detectives are not asking a question designed to elicit an incriminating response. They are, at that moment, simply identifying who they are and what they are there to talk to the defendant about.
Hey, can you pause it a minute, Nick?
And respond.
So it sounds like what's going on here is the defendant made a statement that could be inculpatory, incriminating, prior to being read his Miranda rights.
Right.
And if so, that would normally be admissible unless he already should have been read his Miranda rights. And you're supposed to be read your Miranda rights before the officers start questioning you as a suspect and trying to get substantive information out of you about the alleged criminal offense. So if they're asking you, did you do it, and they haven't read your Miranda rights yet, that's not going to be admissible because they should have Mirandized you before asking you that particular question. If they're merely trying to identify you, is your name John Doe? That's got nothing in particular to do with the case. They don't have to Mirandize you before they ask that question. So what's happening here is apparently the defendant, and this is very bad for self-defense too, by the way, folks. If someone asks you, hey, we want to know about your involvement in the shooting, and you go, what shooting? It's pretty difficult then to justify that shooting as lawful self-defense, right? Because you're claiming it wasn't you. You didn't do it. You don't know anything about it. Self-defense, your claim is necessarily the opposite of that. You're not saying it wasn't you. You didn't do it. You're saying it was you. You did it. You shot that guy, but in lawful self-defense. If you deny you did it, it couldn't have been simultaneously self-defense. So in effect, by feigning ignorance of the events, he's disavowing any involvement, which is contrary to a claim of self-defense. So naturally, the state wants that admitted. The defense is going to try to argue, well, you shouldn't allow that in because he hadn't been Mirandized yet. And that's the nature of the argument going on here.
Yep. And what he just mentioned in the prosecutor mentioned in his statement was very, very important. Miranda warnings need to come prior to a question intended to elicit information about an investigative act. Like that's the questions that the Miranda warnings apply to. That's the questions that your right to remain silent apply to. You can have a right to remain silent and assert it, and the police officer can ask you afterwards, if you like the Bears or the Green Bay Packers. Like he can talk to you about things that have nothing to do with your case. And often that is a tactic that police officers will use, is to get someone talking again. They will talk to them about something else. But they are not allowed, once you assert your right to remain silent, to ask you further questions to try to elicit those types of answers. But they can talk to you about other stuff. And so that's what he's talking about here. He's not offering this in response to that type of question. They're identifying who they are, and they're trying to identify who he is, and that he is intelligibly able to understand what is happening. Because let's say the guy had taken a bunch of Xanax and is out of it at the time, then he's not able to give statements to a police officer, and they would want to identify that sort of thing. Are you on any substances? Are you drunk? Can you consent to this interview, basically, and intelligibly waive your rights?
Yeah.
So here,
Another thing that can come up in these kind of scenarios, and I've known police officers to do this. It's kind of a clever trick, but you assert your right to silence. They're not allowed to ask you substantive questions about the case anymore.
Right.
That's supposed to be done. But what I've seen them do is you'll be sitting at one end of the table and they know they can't ask you questions about the case anymore. But a couple of detectives will sit at the other end of the table and start talking with each other about the case. They'll start saying, so what do you think happened here? And the other one will go, well, I think that guy's just a racist. He just murdered that dude. And then you, because you're shocked at this interpretation of events, burst out, no, that's not what happened at all. It was completely different. And you start talking about what happened. Well, if you reinitiate communication, you've effectively waived your Miranda rights, waived your right to silence, and they can start asking you questions about what you just said. And you can reassert your right to silence. There's no problem with that. But I would encourage you not to get involved in this hamster wheel in the first place. Once you've asserted your right to silence, keep your damn mouth shut. I mean, of course, you can ask for a glass of water, to go to the bathroom, stuff like that has nothing to do with the case. But don't be tricked into you yourself effectively waiving your right to silence by spontaneously deciding you want to talk about the case.
correct. Okay, here we go.
Well, what happened in Milwaukee? Right after that, they read him his rights. He asks for a lawyer. It goes no further. It's done. I'm not going to, under any circumstance, and the court knows this, I am not under any circumstance going to bring in the fact that he decided not to answer any questions or talk to the police. I can't. That's his constitutional right. I won't even touch it. Now,
Binger.
Then I've told this to defense counsel, this is where this gets a little bit potentially problematic, but I still think it's okay. Because in this situation, the defendant, who is now claiming self-defense, has two detectives sit down and state, we want to talk to you about what happened in Milwaukee. And the defendant, who is on the run from that incident, acts as though he has no idea what they're talking about. I think that is relevant. Now, I would argue that potentially it's relevance in my case in chief. I could see the court saying, look, it ends up getting into an area in which the jury could be led to believe, it could end up touching on his right to remain silent. So I'm not even seeking to introduce it in my case in chief. I don't want that. But if he takes the stand and he starts saying that he was acting in self-defense, I do believe one or two questions about the fact that when detectives walked down and said they wanted to talk to him about what happened in Milwaukee, and he responded what happened in Milwaukee as though he did not know, is relevant for the jury to understand for the same reason. I don't believe I can go any further than that. I don't believe I can make any other argument other than he was provided an opportunity and he acted cute, and that's it. I don't necessarily know that the court has to make the ruling now because I'm not seeking to introduce it in my case in chief. But if the defendant takes the stand, I do believe that in this situation, when the detectives identify themselves and state what happened, they want to talk to him about Milwaukee, and he acts as though he has no clue about an incident in which he shot someone in the face, I think that's relevant for his credibility. And I would simply note, defense counsel objects saying, well, he wasn't giving us Miranda warnings. Miranda would matter if I was attempting to bring it into my case in chief. They're not arguing this is a good child violation. They are not arguing that this is coercive. And it is that that prevents me from using it in rebuttal or in terms of impeachment of the defendant's testimony. And it is that reason why, Your Honor, if the defendant testifies, I should be allowed to use this small portion in a limited fashion under the strict guidelines we've just talked about.
Judge, I think if he were to say, no, I didn't do it, then it would be proper rebuttal. But that's not what this is about, right? These are just statements that are a question that's asked by the client. He doesn't know who the detectives are. You know, they've come all the way from Milwaukee to Kentucky. I mean, the states agree that they're not going to introduce it in their case in chief. As to its relevance, I think it'd only be relevant if he said, yeah, I'm not the person who did it. That's not what this defense is about. So I don't see it, why it needs to come in, because this is all pre-Miranda.
Well, I think that's one I can table until the trial. The state said they're not going to use it in their case in chief. If the defendant testifies, it may or may not be a legitimate brief inquiry of a question or two by the state on rebuttal if the defendant testifies, but I don't think I need to rule on that today. So I'll take that issue under advisement and deal with it as the trial is progressing after I see what's been asked. Is the defendant testifying? And we can deal with that then. Any other issues from either side we should be dealing with today? And just so I'm clear, if there's something of an emergent
He talks
nature,
like me talking to my ex-wife. Is there anything else we need to discuss before I hang this phone up?
Are you done yet? Are you done? Can I go? I'm tired of sitting here.
I just don't want continued, every 3 days between now and next Tuesday when the case is going to.
Look at this judge. He's got his law books and he's got the football picture up above him. Football is above the law in this courtroom.
We're going to start voir dire. Mr. Huebner, anything else from the state?
Amended information.
All right, do you want to make a record on that? I know we discussed that off the record with the attorneys. I believe the defense is aware of this situation, but if you can make a record on that, please.
Your Honor, from the very beginning, I have told the defense that if we were to try this case, I would be filing an amended information. I filed it several months ago, I believe, I think in November, if I'm not mistaken. We've put it off until the final pretrial. We ran out of time at the last final pretrial. Then the jury trial, we know what happened there. So we have the.
Yeah, they went from reckless homicide to intentional first degree.
But it sounds like it wasn't last minute. It sounds like they notified the defense months ago that they were planning to do this. I mean, folks, this is a tactic the state might do to threaten to escalate the charge if you don't take a plea or come to some kind of accommodation. And then they don't actually do it unless you compel them to go to trial. If they have to fight the trial anyway, they may as well fight for big stakes. And it sounds like they notified the defense months ago that this was on the table and just introduced it in court, I guess, into the file. Just, I don't know, whenever that last hearing was a week or so ago.
Yeah, well, they wanted to get it, but they didn't actually hear it at the last hearing because of the time was too short for the hearing. They must have only had like an hour. Mo says Russia to send repeat offender maps to Arctic labor penal colonies for life. Thoughts?
I don't know what a map is.
Minor attracted person.
Oh. I presume they don't mean like coal miners.
No.
No.
I have no problem with this policy. Especially repeat offenders. Sometimes people need to be removed from society if they remain a danger to it.
Is there a distinction between a map and someone who actually molests children?
Well, in this case, repeat offender map. So,
well, then one offense is enough for me.
Yeah,
I mean, pull the plug,
or the trigger,
or whatever. I mean, I think that's I would consider that sound social policy. But
seems like it to me. But here we go. back to this
opportunity now. It is timely. It is related to the charges for which the defendant was originally charged. I think it's a proper filing. I don't believe the defense is objecting, so I think we should, because I don't believe there are grounds to object. So I think we should do the arraignment of the amended information.
Judge, I am not stipulating to that. I know we've talked about it multiple times. In this case, we have a video which shows a threat of force, and then Mr. Edgecomb's response to that. Now, whether that was reasonable or not, that's a jury question. But for the state to try to allege when we know for a fact there was self-defense involved, whether that's unreasonable or reasonable, again, that's a jury question. We have at most a second-degree reckless homicide.
He shot a person in the face, and that's a jury question. And by the way, all that matters at this point is whether or not.
Yeah, can you pause it a second? So what's happening here is there's actually three possible scenarios here, right? There's perfect self-defense, which would mean that there's zero criminal liability. It was just a justified shooting. There's imperfect self-defense, meaning it was not perfect self-defense. You can't get an acquittal. The use of force was maybe subjectively in self-defense. He believed he was acting in self-defense, but that belief was unreasonable under the circumstances. So if your use of force was not objectively reasonable, it's not lawful self-defense. It fails that element of reasonableness. Then typically what happens is what would have been murder gets mitigated to manslaughter. What they're calling here second-degree murder is essentially the same thing. The third bucket is it's just murder, that he just got pissed and decided to shoot this lawyer in the face and kill him. And that's just murder. Murder doesn't require deliberation. You can form the intent for murder in an instant. It doesn't require pre-planning and rope and duct tape and all that kind of nonsense like you see on TV. But there's three buckets: perfect self-defense, imperfect, murder. The defense wants to pretend there's only two buckets: perfect self-defense and imperfect self-defense, and therefore murder should not be on the table. That's nonsense. The facts here could easily support murder as well. So the jury has to decide not just between the two, perfect and imperfect self-defense, but between the three: perfect self-defense, imperfect, meaning second-degree murder, or first-degree murder.
Yeah, and that's where a lot of people get confused, because as you learn about like first-degree murder, for me, like I learned about first-degree murder when I was young because my mom was on a first-degree murder case as a juror, and so I learned the distinction. But they talk about premeditated, or that you planned it, is how it's usually described. But that indicates like, oh, he's going to be at this place, I'm going to show up at that place, I'm going to kill him. I mean, while that is a premeditated murder, premeditation can happen in a moment. It's your decision to cause the death of another person consciously. I am going to point a gun at someone's head and pull the trigger. You know that the likelihood of death is high when you do that, and that is your decision to do so. Not like you fired in a direction and a bullet struck them, or you fired at them from a long way away, or something like that. But you're making the decision to kill specifically. That is first-degree murder, and that's the other guys. He shot him in the face,
right?
Like
it wasn't like a ricochet off a sidewalk or something. You might argue that he never intended to actually cause him harm, but should have known there was a risk and consciously disregarded that risk. That's reckless, right? We've talked about that in the Kim Potter plays. Here he pointed a muzzle at a guy's face from a few inches away and shot him in the face. That's absent self-defense. That looks a lot like first-degree murder to me. Now, all this other stuff, this pre-planning stuff, the rope, the duct tape kind of thing we talk about, that could be an aggravating factor. I mean, that could be a factor that might lead to capital punishment in a capital punishment state, or it could lead to, I probably shouldn't say sentencing enhancement, but be an aggravating factor in a sentencing consideration by the sentencing judge for sure, because it means you had a lot of points in time when you could have reconsidered that decision.
Right.
But none of that is required for intentional first-degree murder, which can happen in a moment.
Yep. And if you point a gun at someone's head and pull the trigger. Oh, and in a self-defense case, you should be manifesting the intent. Like that actually, that makes a lot of sense, right? You're not recklessly self-defensing.
No, it has to be intentional.
Yeah. You're choosing to utilize deadly force against someone. So it does make sense that, that first-degree murder charges would go hand in hand with self-defense charges. That it was one of the issues with the Rosenbaum case, that they charged as a reckless homicide was actually very confusing. And I think we had some speculation even on the panel at the time that we thought maybe they were trying to get around the idea of self-defense by saying it was reckless rather than intentional, or trying to do an end run around it. But okay, here we go.
probable cause of a felony was found. At that point, any felony that is wholly related to the incident is allowed. The defendant took a gun and he shot a person at close range in the head. Whether or not that is intentional or reckless, first or second, is something the jury can consider. The state is well within its right. The defense has been placed on notice. There is no prejudice to the defendant in terms of the filing of this information, and that is why it should be allowed in at this time.
And Judge, I misspoke. I meant second-degree intentional homicide. When there's an unreasonable amount of force used, that's what the state is alleging here. So they can charge that.
That's not what I'm alleging. I'm alleging first-degree intentional.
All right, just for the record, before
Very sloppy use of force law reasoning here.
information.
Maybe deliberate by the defense just to obfuscate the actual point, because he's on the losing end of the argument. So he wants to cloud the water as much as possible.
I'm not sure it's based on what the defense has been doing today. I'm not entirely sure it's deliberate. I mean, maybe it is because their case is so bad, and I should give them, I guess, the credit that they might be more competent, but they seem out of their depth on how they've been conducting this hearing. But this is my only exposure to them, so I don't know.
Yeah, and it's hard to say. I mean, listen, if I was representing this client, I might be making these stupid arguments too. I mean, if all you have are stupid arguments, you make them, right? I mean, if you took the job to zealously advocate for that client, that's what you have to do. But they're not strong arguments, and he's kind of flailing around. Now it could be he's just stupid and doesn't actually know, but I'm not sure where the good argument is for him. So it's hard to differentiate between those two scenarios.
Yeah.
By the way, to the extent that this prosecutor seems a lot more reasonable, like Binger, you tend to get more reasonable prosecutorial conduct when they have a good case. When they have a case on the legal merits, they don't have to resort to nonsense then, to circus tactics. It's when they don't have a case on the merits that they have to make up a bunch of bullshit to try to sell to the court and sell to the jury. So to the extent this prosecutor, and maybe this prosecutor would have done this anyway, who knows? I don't want to label every prosecutor like they're a Binger. That's not the case. But it's not surprising to me to see a much more reasonable prosecution when so much of the facts in the law appear to support the prosecution's actual case in chief.
Right. And conversely, it might be why the defense seems to be flailing is because if they don't have good facts and good law on their side, the saying is, right, if you have the law, pound the law. If you don't have the law, pound the facts. If you don't have the facts, pound the table. Right? Yep. Something like that.
For sure.
Discussed this at least once on the record, and I know it's been discussed off the record, that the state was intending to, or at least considering filing an amended information. The amended information charges the defendant with first-degree intentional homicide, use of a dangerous weapon. That's count 1. Count 2, bail jumping as a felony, and count 3, bail jumping as a misdemeanor. Obviously, it modifies count 1. It does not modify count 2 or 3. Obviously, the defense has their own position in terms of what occurred or did not occur here today. Or strike that. What occurred or what did not occur on the date in question, September 22nd of 2020. But beyond that, I think the state's correct. I can't even conceive of a reason I could or would prevent the state from filing an amended information. It happens routinely in Milwaukee. Sometimes amended informations modify the charges up. Sometimes they modify them down. Sometimes an amended information adds additional charges. It's just sort of par for the course. But Mr. Ahmad, what would the objection be?
Well, Judge, in addition to what I've stated, that at best this is a second-degree intentional homicide, I feel like this is a sort of trial tax. I mean, Mr. Edgecomb does have the right. This case was charged as a reckless homicide. And now the defense has about 15 witnesses. We are on the eve of trial. I know that we were provided notice, but this tactic, I think, a case should be charged the way it is and not
This is not a legal argument.
Penalty just because the defendant.
No, this is not a legal argument at all. Hey, what's up, Kurt? How you doing, man?
I'm completely stressed out of my mind through my day job right now. I've got 48 hours left. I'm just taking a small mental break from my day job because there's only so much patent analysis I can do at one time before my brain burns out. So I thought I'd deal with something easier, like a first degree homicide trial for a little bit.
Welcome, brother.
I noticed people in chat were concerned about me, and that's the reason why I have a January 15th and realistically this Friday end of business drop dead date that I have to hit. So yeah, I got 48 hours left, and yeah, fun times.
Always fun to have critical deadlines. But at least actually having deadlines is nice, except when you come
I
up
tend to work better when things are really, really stressful. So I tend to do my best work. But it's not great for my mental health.
Yeah, no kidding. By the way, there's a guy in the chat asking why you, Andrew, said that, you know, this, and I've said the same thing so far. It seems like the state actually has a decent case here. I mean, I can start, but I don't know if you wanted to say anything about it. The case is pretty straightforward as far as it goes. As from the state's perspective, they've got a guy who pointed a gun at someone's head, pulled the trigger, and fled the scene. Fled the scene to another state.
All right, so right away, prima facie, it looks like first-degree murder to me. Now, there could be a narrative of self-defense, and I'd love to hear it. I'm waiting to hear from the defense in what way their client reasonably perceived a deadly force threat against which a gun would be an appropriate response. A shot to the face would be an appropriate response. That could exist.
Right.
You know, I'm just waiting to hear it. It's like in the Rittenhouse case where you take an initial look at the evidence and you see every time he shot somebody, he was obviously being physically attacked with deadly force. So there I'm like, well, it looks like self-defense to me, but I'm open to the argument that it's not. Let's see the evidence from the state that's contrary to self-defense. Here, the initial view of the evidence makes it look like not self-defense because I haven't yet seen a deadly force threat from this lawyer to the defendant. And absent that, it's unclear to me how the shooting in the face could be legally justified. But I have an open mind. I'm just waiting to see that evidence.
Well, if he shot his lawyer in the face, I'm done. Just
it's not his lawyer.
Crucify him. Oh, okay. Well,
it would have been funnier if it was his lawyer, but no, this is just a random happenstance lawyer, an immigration
Well, for the
attorney.
sake of the profession, I'm still saying crucify him. Crucify him. You know, no.
I was
going to
say give him some laurels, like right, like let's promote this guy to public office. I was like, oh, he shot a lawyer, good. Get rid of the competition.
What is that from Henry VIII? First, we shoot all the lawyers.
Yes, one of the most misunderstood Shakespearean.
It is
lines.
incredibly misunderstood. Yes, it means basically the exact opposite of what it seems to imply. Yes.
Right. At least that's what all of us lawyers get together and talk about when we're drinking at the bar. No, but I mean, again, the difference between this and Rittenhouse case, in Rittenhouse, he's clearly being attacked. In this one, the attorney does get very close to him, and there's an allegation that he had a knife, and there's an allegation of a death threat. So far, I've only seen the allegation of the death threat come from the defendant recently, and the allegation of the knife come from the defendant recently. I have not seen information currently, and maybe it exists. I'm not fully polished up on this case yet. That's part of what we're doing here. I have not seen evidence that the police collected or recovered the alleged knife from the crime scene or something like that. From what I know, the knife theory has been put out by the defense well after the fact of the incident. And remember, this guy fled for 6 months, which makes him look very, very bad. So I think the prosecution here smells that this was a time where the guy intended to kill someone. I mean, he may not have thought about it that morning, but he certainly thought about it when he pointed a gun at someone's face and pulled the trigger, and that could be enough. But again, it is possible. I mean, they do have a cognizable self-defense claim in that the attorney was pursuing him on foot, got close enough to have stippling on the forehead, which means he's within probably a foot, well, I think in Rittenhouse, it was like within 4 feet. So he's within 4 feet of the barrel of the gun. And it looks closer, but the video is blurry. But there's also evidence that he purportedly video evidence that he punched the defendant literally seconds before the other video takes place. So that the defendant punched the victim. Sorry, my mistake. I misspoke. So that the defendant punched the victim literally 10 seconds prior to the shooting incident occurring. So the question of who's the aggressor. Did he clearly communicate that he had withdrawn from the conflict and all of that stuff?
But so he punched him, but then he distanced himself on his bicycle, right? Because the victim here had to pursue him on foot. So I don't think the punch is that big a deal, to tell you the truth. I mean, the proper response there is to call the police and say, this guy punched me, and file, simple
Isn't
battery
a punch
charges.
also suggestive of non-deadly force?
By who?
I mean, by anybody. Like, punch typically doesn't suggest deadly force.
Oh, no, that's the punch thrown was non-deadly force in this circumstance, for sure. It doesn't mean he wouldn't use deadly force later, though. I mean, he might have been angry that someone was following him, that he was actually going to get nabbed by the police. He wasn't just going to get away. He's going to get arrested. He had outstanding legal issues. He would have been in prison. So that may have angered him enough to, form the intent to kill. Who knows? But even if whatever the punch was, if he punched the guy and then moved away, that fight's over. And I think the way he moved away was constructive information that he was withdrawing from the fight and didn't want to fight anymore. If it was a sustained beating through the car door, that would be a different circumstance. But that's not my understanding of what happened.
Yeah, and we haven't seen the video, but I'm under the impression it was one punch.
Yeah, means nothing really. When the parties separate after that one punch, it doesn't mean a great deal.
Here we go.
And it wants a trial and has a right to be heard, especially in a self-defense case. So that is a different case altogether. And I think somebody's rights for due process should be respected, that they should be given a trial when they're saying this was in self-defense. And now Mr. Edgecomb is going to face a first-degree intentional homicide charge that carries a mandatory life sentence if he's convicted. And it just ups the stakes. But we are going to proceed to trial, Judge, as planned next week.
Mr. Huebner, you want to make a record on it, please?
Your Honor, what defense counsel is basically requesting is that the state, if we were to follow what he just stated, to file every single charge possible at the highest level every single time we issue a case. That's not appropriate. That would be an abuse of discretion. In this case, I issued a charge that I believed, starting off with a first-degree reckless. I have been very clear, as the court knows, that in those situations, I am willing to negotiate. But if this goes to trial, I am going to try it as a first-degree intentional. The defense is that he intended to kill somebody. So I don't understand how this is any situation other than a first-degree intentional. That's what we have to deal with. I cannot issue a second-degree intentional, although a jury could convict of that if they so choose, because I cannot concede under the statute that I am unable to prove first-degree intentional. That's what I have to concede. I don't, because I do not believe I cannot prove first-degree intentional. So I cannot issue a second-degree intentional because I cannot concede that in good faith. I do not believe it. I don't believe the evidence supports it. Here's what matters. When a preliminary hearing happens, a commissioner finds probable cause of a felony. The state then is able to issue all felonies that are wholly related. Clearly, first-degree intentional homicide is related to first-degree reckless homicide. It's an appropriate charge. In this case, the only objection the defense could make is if they did not have notice. They've had notice for months that this was coming. There is no reason not to allow the filing of this information.
Done.
I like this prosecutor's argumentative style. He's very, I mean, he's into it. He's
fighting for it
when he argues. Yeah.
It counts. It means something to him.
I find his tone a little bit overly aggressive.
I'll take it, because Bingers was like, oh, I don't know what he's doing there. I hated that, that questioning thing. I'm just asking him about why he had an attorney and didn't want to talk to anybody else. That's all I'm doing, Judge. I hated that. This guy seems much more direct.
Fair.
And Judge, just for the record, we are not alleging that he intended to kill him. He intended to act in self-defense or intended to shoot. Those are two different things.
Not really.
Right. But in any event, the state's correct.
You intend the reasonably foreseeable outcomes of your conduct.
No. You know, as a self-defense expert, we intend to use self-defense to stop the threat, not to kill. Right?
No, not really. I mean, you're held responsible for the reasonably foreseeable outcome of your conduct. So it's.
Well, then I
I
got
cut
shut
myself
down
off
hard,
there.
and then Andrew
You
leaves.
did.
Great.
All
He's
right,
back.
I'll be right back. Just a moment distraction. Hold on.
Okay.
No, Andrew is so displeased at my challenge.
That's right.
He is rage quit on me. Okay, well, drama here over at Nick's stream, I guess.
There's always drama here. We're bathing in drama every day, rubbing it all over our shoulders.
More paper crisis. Sorry about that. It's
You're in the great paper depression of 2022. Okay, here we go. We'll resume this. This should be over fairly soon.
File and amended information. I know that the state has told me and told the attorneys previously on more than one occasion that if this case is not resolved, the state intended to modify the charge from first-degree reckless homicide to first-degree intentional homicide. They filed the amended information. The defense has had notice. Count 2 and count 3 remain the same. The circumstances, the incident in this case, the witnesses, how this situation went down with the shot being fired by Mr. Edgecomb, allegedly, though again, everyone pretty much agrees on what occurred. The dispute is whether it was a homicide, first degree intentional, first degree reckless, or otherwise, or if it was self-defense. So noting the objection, I'm allowing for the filing of the amended information. Counsel waive reading, I presume?
Yeah, so we would enter a not guilty plea at this time.
All right, I'll accept the waiver of the reading. I'll accept the not guilty plea on behalf of the defendant on counts 1, 2, and 3. Again, it's only count 1 that's being modified. In terms of the trial, gentlemen, I will plan that next Tuesday will be the same as if it was a Monday. We'll pick a jury. I have just 1 or 2 other cases to call next Tuesday. I'm going to bring up a jury of hopefully 45 or 50 people. Just like I had planned last week, we will not do jury selection in this courtroom. We will most likely do it in room 500 of the courthouse, but I will, or my clerk will advise you as to where voir dire is going to occur, probably in room 500 of the courthouse, but certainly in a courtroom that's larger than this one to accommodate the extra jurors. After the jury is seated, and I'm planning on keeping 14, I'll keep 12 plus 2 alternates. We'll obviously start with openings testimony. I don't need a final answer, but from both sides, Mr. Huebner and from the defense, generally, how long are you anticipating that once we seat a jury, the trial taking in terms of days and witnesses?
1 moment. Let me pull up my notes on that issue.
And Judge, we do have a few more issues to discuss.
Oh, dear God.
Before we recess.
I thought we were getting to the end, but okay.
Your Honor, in terms of your question, I have myself right now at anywhere between 19 and 20, 21 witnesses. So I think we'll probably go till Friday. I think
Did
the
witness
defense
shoot him in the face? Yes, no further
is at
questions.
least going to call the defendant. I think there's a chance that we go into the following Monday.
All right, I don't need a final answer. That was what I was anticipating Friday, possibly rolling it over to the following Monday. Mr. Ahmad, anything else you said?
Yeah, Your Honor, we have a couple issues. First being wanting to take a proactive approach as it relates to the COVID issues that remain. We would ask the court for a provision or order for any witnesses that contract.
A little obnoxious, this other defense attorney suddenly pops in at the end and has his own issues he'd like to discuss with the court now. I mean, the court thought they were wrapping up.
Are there 2 defendants?
No,
2 defense attorneys.
2 defense attorneys.
No, I was just curious why both of them are speaking. That's why I asked.
They've been doing it the whole time.
Okay, pressing on.
So, outside of the last 20 minutes, I should say. At the beginning, though, they were kind of trading off.
COVID and have a positive test or positive reading, that the court would so allow those witnesses to testify remotely in that instance. That was the first. The second is, as the court is aware, we do have a forensic expert relating to the video, and we would also ask the court to allow him to testify remotely as well if possible.
Well, as far as COVID and any witnesses testifying, that could be a problem, but It's a possibility, I guess. Mr. Huebner?
Well, first of all,
I'm not ruling on it yet, but go ahead.
I understand that. I think it might be a little too early for us to tell, but the defense needs to understand that whether or not witnesses testify remotely is a constitutional right your client holds. And so he would have to give up his constitutional right to confront the witnesses in front of him. So we would have to, before we could make any ruling, have to have a colloquy with the defendant that he is giving up a constitutional right, because that's what's happening there. I don't have a problem with it. If
That's correct. And not only is it constitutional, I believe there's a statute that addresses that exact issue.
There is.
That says the defendant has to affirmatively waive his right to have a witness, any witness that's testifying against him, or I guess even for him, not be present in person, which obviously facilitates more easily effective confrontation and cross-examination. Go ahead.
I would note, Your Honor, the very first trial that we tried to do in your court back in 2021 or 20 sometime, if the court remembers,
Back to work, guys. I'll try to catch in with you later.
All right, later, brother.
Okay, Kurt.
2021. That was weird. That was weird.
Ran into a detective that wasn't allowed in, and we tried to set up, and it involved us having to set up, and if the court remembers, I was in here and I ended up setting up 3 different computers with 2 different Zooms working to make certain that the witness would then be able to also view the exhibits. Because that's the main thing you have, is that not only are they testifying, but we have to make certain that what they're seeing is exactly what the jury gets. So in terms of...
And I have to be sure that they're not seeing something they shouldn't be seeing, which is a concern for the court and should be a concern for the defense, because depending on who the witness is, I don't want them looking to, reading or referring to something that they would not be able to refer to in front of me because they happen to be on a Zoom screen. But
you don't want to witness Googling a news story about this case that they're testifying about while they're testifying. Very bad.
Reading from notes or something weird like that. The witness is supposed to be testifying from their own memory. If there's notes and things like that, those can be used. The witness can transiently look at those to refresh their recollection, but their testimony is not just reading words off a piece of paper. It has to be from their memory. Every once in a while, you get a weird case where somebody does that. In the George Zimmerman case, one of the state medical examiners, was a complete nut job, actually showed up with like a bunch of notes written on a piece of paper and just started reading from his notes. And the defense was like, what do you got there, doc? You mind if I take a look at that? And then he said, no, he wouldn't share it with the defense.
Those haven't been disclosed.
Yeah, haven't been disclosed. The defense is like looking at Don West was the defense attorney on cross there. And he's looking at the judge like, Your Honor, we can't allow this. I've got to be able to look at that piece of paper he's using in his hand.
Yeah. Here we go.
Go ahead.
I can, in terms of any of the state's witnesses, if that is something the constitutional right the defendant's willing to give up, I believe I have set up a system that we can do it. I would note in terms of the defense expert, I'm willing to talk to the defense about that. I keep saying that if they'll just explain to me what was done, we may not even have an issue on that. The main thing with it is, in terms of him testifying, I don't necessarily have a problem with it being over Zoom, as long as we make certain that what he is showing is what we are introducing in evidence here. It can't be something from his computer. It has to be something that we introduce from this computer and is moved into evidence from here.
Which expert are we referring to?
That's going to be the video expert, I think.
It's Mark Robinson, I believe. We provided the state a copy, a side-by-side.
And.
Mark Robinson. We have provided the state a side-by-side of the video, which obviously there's not many changes at all. The only thing that's really changed is just a little bit brighter to give clarity so that it's easier for the jurors to be able to see. But that's
the defense
really
attorneys, the only people in court not wearing masks.
The judge isn't wearing a mask.
Oh, yeah. Okay. It looked like he was wearing one a couple minutes ago, but most of the time he has not been. That's for sure.
Yeah.
I guess the plexiglass, the virus can't get over the top edge of that plexiglass. That's pretty cool.
It's very good, solid plexiglass.
And like I said, the state has been in possession of that for at least 2-3 weeks now.
And I have been, but I would note that the defense keeps asking me to stipulate to it, and I've stated I'd be willing to if they'll just tell me exactly what was done to it, so I can make certain that what was done to what they're saying was done to it, I can recreate or talk to
More
my
pixels.
I haven't been told.
Yeah, no kidding. Interpolation.
It's going to be more pixels. It's going to be, hey, obviously you can see the knife in his hand. I mean, it's right there. It's that pixel.
Yep.
They either let me talk to the expert and he can walk me through it, or, tell me exactly what they did to it. All I've got is 2 videos, and I have no idea what
this guy watched the Rittenhouse trial,
changed to a video,
and he doesn't want to get ambushed like that.
The actual source. And that's my concern, because I don't know what has been done to it. I'm sure, and look, I assume the defense attorneys are like me. They probably don't know, because it's a tech thing. I mean, no, we don't know it. I just want somebody to sit there and say, I use this program. Then I can go to a guy that actually understands computers, and he can tell me whether or not, what changes that have, and then I'll let you know if I have an objection or not.
Again, what should have happened in the Rittenhouse case. This is what should have happened and did not.
And they're trying. So in Rittenhouse, it was the state ambushing the defense with this, video enhancement nonsense, these magic pixels. Here, it's the defense trying to ambush the state.
Right. And so they want to introduce video. They say it's just brightened up and cleared up. And well, maybe it is.
Enhanced.
Maybe it's also enlarged, because the video of this incident is trash.
Yeah.
You can't see anything once the guy gets like halfway up the road.
I don't think I will. I just want to know what I'm agreeing to.
Your Honor, as we said before, we provided the state a copy of side by side. There's no material changes whatsoever. I'm happy to arrange a conference or call this week with the state so that he can, hear from the expert himself. Again, there's no material changes. The only thing that you can really see is that the video is simply brighter.
That's what he just asked for, though, was a conversation with the witness to talk about what happened, so he can then bring it to his own expert. I mean,
and apparently the state's been asking for this for weeks, and it's never happened, which tells me they don't want it to happen.
Yeah, it's very weird.
That's about it. But yeah, we're happy to arrange that.
Hang on, let me jump in. Then you guys work on it. You guys discuss it. Try to come to a stipulation or an agreement so that I don't have to rule on that particular issue. I'd prefer to avoid testimony that's not in person for all kinds of reasons. I would have to have a colloquy with the defendant. Obviously, if that was to occur with any of the witnesses, particularly the person we're talking about, including this potential expert witness. But you guys talk about it, figure it out. Well, let's try to have it resolved by next week so we don't have to argue about this next Tuesday.
Thank you. Anything else, guys?
Yes. Judge, given the realities of COVID and what's going to happen next week during voir dire, I want to know if the court would allow us to submit a proposed jury questionnaire. Given the severity of this case, I mean, it's not something
He just said he doesn't want any more motions.
Given the realities of where we're at, it might make voir dire a bit smoother. I can imagine there's going to be all kinds of logistical issues with the voir dire of 50 or 60 people on the panel.
Your Honor,
well, there are some potential logistical issues, yes, and there are logistical issues and issues related to COVID, which are unfortunate, but Mr. Huebner.
Your Honor, I would just simply note, I've done cases where there are jury questionnaires. Personally, I find them, I don't know how helpful they are all the time, but one of the things that we require is then you have to get all the 50 people in a pool. Then we have to go down there with the defendant. And because the defendant has a right to be there when we have all of these confrontations, or all these talks with the jury. Then we have to provide them the jury questionnaire. Then we have to provide them.
Jump in. All of which is not going to happen in Milwaukee County. It's not going to happen. If the defense and the state or either want to submit a few questions that the court would ask.
Prosecutors got the judge figured out.
Not happening.
Let me explain how much work this is going to be. No, I'm done. This judge has been saying I'm done for the past 20 minutes.
From the bench for voir dire, I'm fine with that. Mr. Ahmad and Mr. Huebner have had trials with me. You know that generally I stay out of voir dire. I introduce the basics of the case. I tell them how long the case is expected to go. I read the allegations. I ask some basic questions. Then I have each of the prospective jurors do their pedigree questions, meaning their juror number, where they live, their occupation, have they been in a jury before? I do all that kind of thing. If either side has a few questions, meaning up to 5 or 6 that you might want to ask because you would feel it's better coming from the bench as opposed to one side or the other, I'm fine with doing that. But in terms of other issues, I mean, Mr. Huebner is correct. I'm not going to know who the 45 or 50 jurors are until they show up in court next Tuesday. Working with jury management in Milwaukee, they have their challenges, I'm sure, but it's not always particularly smooth and particularly easy. So again, I'm going to keep 14, 12 plus 2 alternates. I expect voir dire to be done on Tuesday, certainly. I'm not going to let voir dire drag on for days or even innumerable hours. I expect both sides to get to the point to ask appropriate questions that are appropriate for voir dire. And if either side wants to submit 5 or 6 questions, or for that matter, 2 or 3 that you might want me to ask, that's fine. I'll consider that, and we can take that.
No jury questionnaire for you.
Judge, with regards to alternates, I think it'd be a good idea to have more than 2.
Well,
just because.
I mean, just think about how long it took the Kim Potter. They had jury questionnaires. They did individual voir dire.
Oh my
and
God,
it
Ahmaud
took-
Arbery went on for, was it 3 weeks for voir dire?
Yeah, it was crazy.
I mean, I know I watched 2 weeks and then I quit to move to the Rittenhouse trial. So it was still going on then. Folks, most murder trials are like 2 days. I mean, these trials that are high profile are complete aberrations from the norm. That you would need 3 weeks of jury selection is absolutely insane. But that's the politicized world we live in, I guess.
Right. And yeah, the jury questionnaire doesn't automatically make things go faster. Again, in the jury questionnaire in Potter, I mean, that took 6 days, I think, of 5 or 6 days of jury selection. It was brutal. After Rittenhouse, 1 day, boom, done. That's how it should be.
So, and in Arbery, even after the paper questionnaire, the state on voir dire still had 40 questions they were asking, and the defense had another 20. And the only reason they only had 20 was because the state had already asked a bunch of the questions the defense otherwise would have asked. But that's why it took so long. They had this lengthy questionnaire and then 60 plus questions they were also asking the jurors. It was madness, havoc.
Yeah. Havoc, Your Honor.
Because let's say someone contracts COVID.
Imagine.
Mr. Mott, if somebody on the jury panel contracts COVID, the toilet, it's going to, unfortunately, the case will go down the toilet. It'll be a mistrial because there's no way, if I have 14 jurors that are sitting next to each other, even with plexiglass, that's going to go forward. It would be very, very unfortunate, but I think 14 is appropriate. So state want to weigh in on that. I mean, COVID's a problem. I mean, I don't need to belabor my situation from last week. I read an article, I think in the New York Times, that referred to last week as the week that all of America called in sick because everybody and their brother, including multiple Bucks players, Mike Budenholzer, NFL players, everybody, it seems, either was positive themselves in the last 2 weeks or knew somebody that was. There's also been outbreaks in the jail, in the House of Corrections, in the DOC. Hopefully that does not affect Mr. Edgecomb, but some of this has to be a game day decision. So I'm going to keep
game day decision.
I think
this is a football guy for sure. Bucks references, game day, football, anything above the law book.
Monday. Anything else in the defense?
Yes, Judge.
This trial better be over by Super Bowl Sunday. God damn it.
Talk to counsel about this. I think at this time it's premature technically because we have to review all the evidence before we get to jury instructions and what's appropriate. But essentially, we know what the basic facts are. And the issue for May 15th,
look at the reflection of the cop in the background doing back stretches.
In this case, we know that there was retreat and there was notice of that. So it kind of cancels, given that the defendant regained the right to self-defense, it kind of cancels out the necessity of 815. And it just, I mean, we can listen to the evidence and then make a ruling, but that is essentially what our argument is. I don't expect that to change.
I'll listen to the evidence. I'll make a ruling after we hear the evidence. Mr. Huebner, anything else?
No.
Mr. Ahmaud?
And then, Judge, just for the record, I
815
want
must
to
be
make
a
the
provocation
argument
with intent instruction.
Yeah.
Okay.
And so he's trying to get that ruled out right away. Judge says this isn't the appropriate time. Yeah. And then he says, is there anything else? And the guy says, yes, another thing, Judge. And his soul dies a little bit.
that, again, consciousness of guilt evidence can't be reconciled with jury instruction 805, which just says, you're not to evaluate the case from your viewpoint now. You got to look at it from his viewpoint at the time that the force is used. So
they're scared
I
to
don't
death
see-
of that consciousness of guilt evidence.
Oh yeah, because
And
it
they ought
looks
to be.
it looks terrible that you flee the scene for 6 months,
It
never
looks
call the
nothing like
police.
lawful self-defense.
Yeah.
What he did after really matters according to the law of self-defense. I understand the
Hey,
state.
that's you.
That evidence
I
in
trademarked
any
that
sort of
phrase.
Case they can with flights involved. Then when there's an affirmative defense, and then that's what the instruction.
Hey, the defendant could read your book in jail.
They often do. I get letters from people almost every week. I don't know how they get the book. I don't know if the jail library and the prison library has them or what, but we get letters all the time from people in prison. They're already convicted. They're not even asking for help. They're basically just saying, holy crap, if I knew then what I knew now, I wouldn't be sitting in this cage.
Well, you know how they had that old meme where they would take the book and they would like cut out the knife shape in the book and they put the knife in there. I actually got a really big book and I cut out your book's size and I put your book inside of it.
There you go.
And shipped it to prisons
Smuggle it
all
in.
over the place.
It's better than the other way to smuggle it in.
That's true. That's true. It's a big prison wallet. Be very careful.
Instruction says, how do you reconcile the two instructions? Would say, don't look at this in hindsight, but then we want you to consider everything after the fact. I mean, how does that logically make any sense?
Oh man, what a weak argument.
Mr. Goodberry, count last word, then we're done.
Consciousness of guilt is what the defendant did in terms of his mindset. The moment he committed this act, he took off running. That goes to show, in terms of what he actually and reasonably believed, he knew that it wasn't self-defense because he took off and he kept taking off. And the
Look at
only
this
reason
bullshit
he's even
mask
here
wearing.
is-
Yeah.
With his whole, both nostrils fully exposed.
Well,
and I get it, man. I hate masks more than anything. But I had to go to the damn Apple store today, and they made me wear a mask to get into the Apple. Even though the whole mall, the moment you're out of the store, the whole shopping mall is maskless where we are here.
Oh yeah,
and-
same here. The Mall of America, you can go in no masks or whatever, but there's like 3 stores where they're like, oh no, you got to have a mask. I'm like, oh fuck you.
And they got these big wide open doors, like the air from the mall is not coming into your particular store.
Right.
It's insane. But obviously this guy he's not actually concerned about viral mitigation.
Yep. Eugene says judge reads New York Times, guy gets the electric chair. All right, here we go.
It's because the Kentucky trooper pulled him over and then happened to find his driver's license when he lied about the country he was from. That's consciousness of guilt because he is telling us by his own actions that it was not self-defense.
That's it. That's what consciousness of guilt means.
Over and over.
Right. I've heard the same argument from both sides. In terms of jury instructions, we'll deal with jury instructions when we get to that point, which will be next Thursday or Friday. Maybe Monday, but hopefully next Thursday or Friday. All right, we're adjourned. Thank you.
Done. Bam. Where's that gavel? I want to see this guy with like a 50-pound gavel. Bam. Everything in the courtroom jumps off the table.
So,
make the rubble bounce, Your Honor.
So his schedule is very aggressive.
Yeah.
He wants to be at jury instructions by Thursday or Friday. Jury selection is Tuesday. So, I mean, he's expecting a 3-day trial.
I mean, that would be kind of normal, really.
Yeah.
But, and of course, I mean, I hate to say it, but this is the world we live in. The races are reversed here from the normal politically energized, racially energized case. It's a white victim and a black suspect instead of a black victim and a white suspect. And it tends to be the latter that results in these multi-week, multi-month prosecutions. Again, a normal, a typical average murder case is 2 days, maybe 3, sometimes 1. But 2 days is a pretty typical, you do jury selection in the morning. It takes an hour or 2 and you jump right into opening statements and 48 hours later, you're done.
Yeah, it's been pretty interesting watching. Like, again, the Potter trial was so slow and laborious, partly because Judge Chu was slow and laborious.
I'll allow it.
I'll allow it. And of course the defense or the prosecution parading in every single possible cumulative witness they could. You really don't need that. And if you think about it, in this case, there's as they've got 21 witnesses listed, I guess, that the state mentioned, but really you have the widow and the defendant. Those are the witnesses to the criminal act.
Right.
Maybe
So
someone
they'll have like the medical examiner, they'll have the
Right.
cops who made the actual arrest, and then they'll have the local Wisconsin detectives who had that questioning of him. I don't think they'll get close to 20, but they're obliged to list everybody they might call as a witness, and you never
Right.
call everybody really. So maybe they'll end up with 5 or 6 or 7 substantive witnesses. But you know what they didn't do is they didn't put 500 witnesses on the list, which is what Binger did.
Right. Right. Because and what Binger was doing is trying to increase the cost of trial prep.
Yep.
Make it expensive, make it exhausting, and make it distracting, so that they're not doing something else and working on the defense in other ways. Well, that's the hearing. Doug Murray says, Andrew, how close is close when you can legally appropriately deploy deadly self-defense in a self-defense situation?
Well, I'm not sure I understand the question. If you're asking when is a threat actually an imminent threat against which you can lawfully use defensive force, a good framework for understanding that element of imminence is something called the AOJ triad: ability, opportunity, jeopardy. Unfortunately, AOJ or its equivalent, people use different 3-word phrases for it. Unfortunately, it's often taught as if that were the entirety of a self-defense claim. It's not. It's a good framework for evaluating one of 5 elements, the element of imminence of self-defense. But does someone have the ability to cause harm, the opportunity to bring that to bear? And jeopardy is, are they conducting themselves in such a way that they apparently intend to bring that ability and opportunity to bear against an innocent person? That's an imminent threat against which defensive force would be appropriate. Assuming, of course, the other elements of self-defense are also present.
Yes, and thank you for that explanation. But there is no, I mean, the one thing that you should be grabbing from all of the discussions that we've been having about self-defense on the channel is that there isn't a bright line rule for self-defense, because there is no bright line murder attempt, right? There is no bright line threat. The threat has to be objectively reasonable and then subjectively perceived by the person. So the objectively reasonable part is somewhat bright line, but it's going to depend on the totality of circumstances of the particular incident. And then the subjective thing is actually a very, very different thing. Someone like Eddie Hall or Hafthor Bjornsson or whatever getting attacked by a 5'4" woman might not feel like they're in imminent danger, even if the woman has something, even if they would be objectively reasonable because she's got like brass knuckles or because she's got a knife. They might not actually be afraid of her. And if they were to use deadly force, but not be afraid, even if it would be reasonable for a normal person to be afraid, then they cannot use self-defense. So all of that stuff plays into each and everything. And that's why they can't make rules, because the assailant is different. The victim is different, or the defender, I should say, is different. And then the circumstances around it are going to be different every single time. You're just not going to find 2 exact same self-defense cases.
Right. So, I mean, self-defense law itself, the black letter law, is not generally very complicated. I talk about these 5 elements of self-defense. There's only 5. There's not 50 or 500. So the law is not that complicated. What makes it complicated, what makes the legal analysis complicated, is the facts. The facts are super complicated because they're infinite in variety, and they're often extremely ambiguous and subject to judgment calls and decisions about reasonableness. And that makes it super complicated. And that's why the risk of conviction is never 0 in a self-defense case. Now, there are self-defense cases that are relatively unambiguous, that are pretty clear cut, either pro or con, but we don't tend to see those because the cases that are clearly self-defense don't tend to go to trial. So we never see those happen. The ones that go to trial are where the prosecutor feels he has a compelling argument to make that it was not self-defense, or at least that's what should be the case. I mean, we all see these political prosecutions too. Those are the kind of aberrant ones that tend to get the highest profile, most attention. But a typical and genuine non-politicized self-defense case, it doesn't go to trial unless there's something sketchy about it, because they're too hard to win otherwise for the prosecution. Prosecution has to disprove self-defense beyond a reasonable doubt. If your conduct in self-defense is reasonably within the legal boundaries, that's hard to do. At law of self-defense, we talk about being hard to convict. We don't mean through legal tricks or magic words. We just mean if your conduct's within the legal boundaries, it's awfully hard to disprove that beyond a reasonable doubt.
Yeah. Okay. I've got a bunch of super chats to read. So you are, of course, always welcome to stay, but I wanted to let you know, I always like to let you know when I'm at that point in the show in case you need to go, because I'm going to read the super chats and then I've got to go pick up my kids after that. So
let me do this. I do have to take care of one thing. I'm going to pop out for a second. If I pop in and you're already gone, I won't take any offense. If you're still here, I'll pop the headphones back in and join you again.
Sounds good, man.
Okay.
All right. Here we go. Mark Gee says, not guilty. Attorneys are not human. No crime detected. Great US says, am I on a mushroom journey? Nick is on during the day. He also says, did you miss a couple of tips here? First was super early yesterday because we trusted you to stream during the day. Obviously, we were devastated and almost suicided. It was about virgin ears. And after last night's stream, a handful, including a toast. Unfortunately, no, I can't see those because, again, my computer got shut down. So the leftover chats on Odyssey got cycled out. So sorry about that. Leanna says just take some Monopoly money on me, and also asks if they can get a quick rundown on what this trial is. Just got here. Trial is, a guy shot an attorney in the head, and he's claiming self-defense. The attorney appears to have chased him somewhat, may have had a knife, may have uttered a threat with a racial slur attached. We don't know. That's kind of relatively new information, and this happened a while back. So we'll see how that goes and how that comes out at trial. Radicalized Ryan sent a money comment. Great US says, Dan Abrams, the MSNBC reject at Law and Crime, can suck JM, I only assume Jack Murphy, dick after his Chatterbait session. 2, yes, I'm 90 minutes behind. 3, weekly reminder, Odyssey charges 5% and doesn't block your cussing chats. And then Radicalized Ryan sent a coin. Thank you guys for that over on Odyssey. Techno Geek says, you're breaking my heart, man. Starting to think you don't want to get the sponsorship I've been trying to help you with. Do my super chats really discourage you? No, they don't discourage me. I'm just, dude, I know I say this all the time. I am obscenely busy constantly. Like when I'm not streaming, I'm either working on something involving the stream or the show, or I'm taking care of my kids, or I'm hanging out with my wife. That's the only 3 things I really do: stream, kids, wife, or work on the stream. So if I'm not, the same thing happened with a guy yesterday. He's like, I emailed you and you didn't respond. It's like, well, I have like hundreds of emails that I haven't responded to. I get hundreds of social media messages a day. It's not personal. It's just like on the list of things that my brain is thinking through by the time I get done with a show. This particular thing is not there. And it's not that it's not like low priority. It's just, there's always stuff for me to do. And again, having a super chat, is very much appreciated, but I don't know if sending them is going to be helpful for getting me to do this thing. And I want to do it, but by the time I get off the show, I'm going to forget that you sent this super chat. Like that's the reality of it. So there you go. Mandy Karev.
I'll echo that. I mean, my experience is, folks, I'm at 120% all the time. There is no dead time in my day. If I'm carving out extra time, it's because I'm sleeping less. And you can't do that on a sustained basis. So there's just no time. I mean, I have people send me books. Can I review their book? And man, I don't have 4 hours to read somebody's book. I just don't. I wish I did. I wish I was a millionaire and was just sitting on the beach and I could casually read someone's book and send them my opinion on it. I'd be happy to do it if I had the time. I just, there is no time. There's none. Zero.
Yeah. It's the past 3 days I've had 7 hours of sleep combined. Not each day, combined. So it's like and because I've had to carve out some extra time. So I'm working on stuff, man. And the with Christmas and New Year's, it's been a disaster. Plus, as I said earlier, our nanny has been on vacation, which means that I had to take over all of the duties that I hired the person to help with.
You have to wear
I
that
had
little dress?
no, not that duty. No, no, I had to do a bunch of the driving that I normally wouldn't have had to do, which is why I haven't been streaming as much during the day. And, I also had to wrap up CLEs. So that was fun. Mandy Caravicia says narrow audio urethra. Homboy says don't talk TV. Canuck lawyer check email. Agrilith says, Nick, this will be a short 30 minutes. Stream ends after 9 hours. Contrarian 420 says history ends in Tyranids rackets. Also, hashtag free Chandler. Also, 6% of COOF deaths had no comorbidities. New Age Cuck says, did the African-American child that pew-pewed his school ever get charged? I think so. Yeah, he's out on bail. Deep Surface says, here's $2 for microphone school. Boomer. Yes. Alex Iao says, from Michigan here, close to Oxford, think the parents will be let off. What do you think the consequences will be long term? I don't think the parents can be charged under a current reasonable understanding of criminal liability or can be convicted, but they have been charged. So that could change immediately. Then it becomes in the hands of the jury. And I think that's a bad precedent. Bastiat says, I'm more interested in the parents. How's it possible they are charged and not the school? Could I get some information to understand? No, you can't, because the new evidence shows that the school knew even more than the parents. The school knew even more about the parents and had more warning signs that they ignored, including a potential threat the day before it happened. So yeah, there's no way to understand it. The school seems to be at least as liable as the parents. And I don't think either are liable, frankly, because you can't actually predict a mass shooter is going to come to your school and shoot it up. You can't do that. And in hindsight, him quoting Oppenheimer saying, I am become death, the destroyer of worlds. See you tomorrow, Oxford, doesn't actually say I'm going to shoot the school up. Like, it's a famous quote followed by see you tomorrow, Oxford. So,
I mean, we often talk about the fact that, politicians, leaders of cities and such will gladly settle lawsuits with other people's money to make their political problems go away. This looks to me like the school is afraid they're going to take heat for not identifying this kid as being dangerous. I agree with Nick. I don't think you can really hold the school accountable. I mean, teenagers say nutty things all the time. He never made an explicit threat to harm other students at the school. But the fact that it wouldn't be reasonable doesn't mean the school doesn't believe they could take political heat for it. And political entities will gladly spend other people's money or facilitate other people getting charged with felony offenses if it reduces their heat. And that's the sense I'm getting from what's happening here.
Yeah, absolutely. And the school system is a state institution, and the state is the ones doing this. Putting the blame on the parents makes the state look less guilty to the state. Dermy Wormy says, out of the 4 people, how many bites did he take? That's a good question. I don't know. I don't know how many nibbles. Voice of a Free America says, what's your take on the British Columbia Ronald McDonald House kicking out unvaxxed children with cancer? Seems like a bad move. Seems very stupid. But we live in a weird world right now. Alex Iao says, from Michigan, they're trying to push a new law that all guns have to be under lock at all times, no matter what. That was DC versus Heller, and it didn't work out. That seems to be in direct contravention to DC versus Heller. So hopefully that'll get struck down.
A lot of legislation is proposed just for the political theater of it, not because anybody thinks it'll be passed and or is constitutional.
Right. New dislike button says, Crumbley Ralph, as the king of the Ethans, I hereby apologize and denounce these lunatics. I banish them from our society, them and their guns. Slammer says Potter judge released a criminal, then he vanished. Yep, she gave him 3 hours to go to a funeral, and then he pieced out and is gone. Brixton Yorker says legal mindset. I have a crush on you. Can I DM you? Yeah, give it a shot. I give you permission to DM him. As long as you send him pictures, never mind, of naked men. Linux Charm says House of Blues Orlando won't refund my $160 ticket because of their mandates. DeSantis won't stand up to testing mandates. I'm so tired of complying. Tomorrow V says if you listen to the CDC hearings live stream, they make decisions based on emotional arguments about their kids' school attendance, vax boosters for 12 to 17, and language for consistency. The one thing I don't want to do is listen to a CDC hearing live stream because that will get you struck off of YouTube when the CDC contradicts itself. Richard Fada says, can you explain these curfew violations that people are getting fines between $100 and $6,000 for? My uncle's up in Montreal. No,
I don't know anything about Canada.
Yeah, and if it's a curfew violation, I think curfews are in the U.S. should be presumptively unconstitutional, and I don't think they should ever exist at all. I don't care what's going on. I don't agree with curfews. Contrarian 420 says Pfizer couldn't secure legal immunity in India. Cue shortages. Pharma spends more than any other industry on political lobbying, 3 times oil and gas. Long story short says, I used to work with a guy that was from communist Romania. He told me that his mother used to have to give the doctor a carton of Kent cigarettes. This name is fine. Says, how can a 12-year-old waive their right to remain silent without a guardian present? Happened in Slenderman stabbing. Doesn't seem right. It might not have been right.
Yeah.
Eric Johnson says, hey, Nick, is there any news on missing Bicep Boy's civil lawsuit for the $10 million? Did he drop it? As far as I know, it's still on, but I have not looked. I'll see if I can find news on it. Patrick Allen says, what lawyer drives a Kia Soul? I guess an immigration attorney in Wisconsin.
Oh, was that the car he was in?
Yeah, not a good look. Atlas Shrugged, welcome to paralegal status. Thank you. Havelock Veterinary says there is a temporary concrete wall being erected around the White House. Speculation, please. They believe in the wall.
Are they bricking it in? that
would be fine. Yeah, maybe it's being built by other people. Just don't worry about it, Joe. We're just keeping you inside. Just please don't come out. Trashman says, Your Honor, what person in this great state of Wisconsin hasn't both driven and handled weapons while drunk? We're known for our beer. Alex Iao says, did you ever hear the story of Nuclear Boy Scout? In Michigan, he built a nuke in his garage. Can we citizens arrest someone making a nuke? I've never heard of that. And I don't know. I think it would depend on what stage of the nuclear weapon they're at. Corpus Delecti says, Nick, what webpage for that webpage for Cannabro's girlfriend was for her acting in a play he held at his college. Not sure you caught that portion of it. Oh no, I didn't. That was at his college that he wasn't attending. That case is wild, man. Dick Thickum says you pronounce gigachad incorrectly. Doc Brown pronounces it gigawatts as in gigawatts, and he invented time travel. I suggest it must be gigachad. Nope, gigachad is the only way to say it. Not giga, not giga, giga. Mo says Spaceballs watch party when? We did one, but we could maybe do it again. Larry and Crystal says Dr. Fauci on David Rubenstein show in 2019 found on YouTube, quote, best way to fight infectious disease is low-tech way, no mass, vitamins, exercise. Well, but he's clearly changed his opinion since then. YouTube, I gave the contravailing statement. Leave me alone. Tamara Holloway says, does it make a difference if the dead guy actually had a knife or just that the defendant mistakenly thought he did? The defendant has to reasonably think he has a knife, not just mistakenly, not just happenstancely thought it. The problem with the defendant is there is no one around that I'm aware of that will be able to testify that the guy had a knife. So all of the testimony is going to come from the defendant if he takes the stand, and it's going to sound self-serving. They have to introduce the existence of that knife somehow. And without another witness, he's going to have to take the stand to say he had a knife. I saw it. here it was.
At which point he'll be brutally impeached by all the consciousness of guilt evidence. So he has no credibility in terms of this being a lawful use of force in self-defense. I mean, there are circumstances you can imagine where he could have had a mistaken but reasonable perception of a deadly force threat. So if the lawyer is shaking his fist at him and the lawyer has a cell phone in his hand and there's a glint and it looks like a weapon or looks like a gun, okay. It wasn't, but that's not required. What's required is he had a reasonable perception of a weapon. The lawyer screaming, hypothetically, "I'm going to kill you," and there's a shiny object in his hand. Okay, I get it. That's a narrative you might be able to sell to a jury. But I'm waiting to hear that, and the only person I can imagine it coming from is the defendant, and the defendant's credibility is garbage.
Yeah, he's gonna get absolutely raked over the coals. The other way would be as if there was a witness who was there, who when the guy, right, when the guy gets out of the car, someone's like, "Bro, knife," something like that. Issues of warning, something.
Even if it's not true,
right? Something to give him that thing, and then presumably you could have that person testify, or they'd be caught on video or something like that. But we'll have to see if they bring something like that. Mike B says, have you read the book Escape from Plum Island by Lorenzo De Tonti? Nope, never even heard of it. Koi 540 says, if you were in a situation like this and had to file motions over a holiday, how would you do it as to not piss off the judge all at once after the holiday? I mean,
I would just file them when I got them done, and the judge will look at them when the judge feels like looking at them. I mean,
yeah, the judge, he bitched about them filing a motion every day, like a new document coming in every day. But I mean, yeah, I think if the motions make sense to go together, then you could file them in batches. Because I could see that judge getting a notification every day over the Christmas break that it might really piss him off. Maybe wait. If you're doing them all during Christmas, maybe file them all after Christmas, like Christmas.
And this motion stuff can get abusive. I mean, during the Derek Chauvin trial, for example, the state had, I don't know, 12, 14 lawyers filing motions throughout the course of the actual trial proper. And the defense was, at least nominally, the defense was basically one attorney who's arguing in court all day, and then is supposed to read, motion scores of pages long in the evening when he's supposed to sleep. But even the judge in that case noted that this is, there's kind of a disparity of force situation there. There's no way the defense can keep up with this volume of motions.
Yeah. Koi 540 says,
I was also going to mention that, folks, first of all, these motions should not be happening during the trial itself. All this should be done beforehand. Ideally, the trial should be completely orchestrated by the time it begins in front of the jury. Everyone should know what the questions are going to be, more or less what the answers are going to be, what the testimony is going to be. There shouldn't be any ambushes or surprises for either side. Everybody should know what the other side's going to say. And the only real question is, well, what's the jury going to make of it? What will the jury believe or not believe to have been proven based on the evidence you present them? All these issues about what's allowed, what's not allowed, what will the argument be or not be, that's supposed to be settled in these preliminary hearings like we watched today. And it would be normal or natural to imagine that a preliminary hearing is unimportant. I mean, how important can preliminary be? But this is where the legal battlefield is being defined for this trial. Right. Everything is being defined here, what that playing field is going to look like. And you can almost determine the outcome of the trial itself by how those preliminary hearings go. So they're absolutely critical, which is why so much time is being spent, like in this case, between the state and the defense, arguing about the evidence, the legal arguments that will be permitted, and so forth.
Koi 540 says, is this a case of bad facts, bad defense lawyering, or both? I don't know if the facts are bad. There are very uncomfortable facts. His fleeing the scene looks really, really bad. And and if he's going to take the stand, someone said he would take the stand. If he's going to take the stand, that's going to come out, and it's going to be brutal when he does it. And they're going to get a jury instruction about how the jury can determine that his leaving the scene for 6 months only to be caught in a different state and then lie about it, that is indication that he believed he was guilty and was running from it. And his defense is going to be, no, I was running from my other crimes. I mean, which otherwise wouldn't be able to come in, except now there's going to have to be some talk about the fact that he was bail jumping another criminal charge. And if he was
Felony.
already, so it's, this is an issue for him. But it could be bad defense lawyering. I mean, they're making bad arguments, but they don't really have good arguments to make. Potentially Criminal says, is there more video than the clip of the car chasing him down? There's allegedly a little bit more. We'll see it soon. Motor City Misfit says it's called hydraulic effect, Nick. I think it's hydrostatic is the word I was looking for. David A. Hamilton says Sydney Watson is asking for guest recommendations on her Twitter. Rackets and Drex need to make the list. I will likely be on their show in February already. So
are you on other people's shows, Nick? You do that?
I do that. Absolutely.
Oh, well, I might ask you to be on my show. My humble little, we've done 3 episodes so far show.
Well, if you you know how to find me, and I'm
right.
happy to do so. But yes, I'm working out the schedule with You Are Here currently, and I think as soon as we have the date locked down, and as soon as I get confirmation that it's fully locked down, I will let you guys know. Very excited. Rajveer Soda says, "Can we get Law of Defense drunk again, please?" Well, not in the middle of the day. C Goody 564 says, "Naggers renegers are no good. Nagging renegers are no good." Okay. Reed Nipper says, "In your opinion, how likely is it that the verdict of Maxwell is overturned?" I have no idea. They're talking about doing a do-over in that case. Sounds like a nightmare. I think I'll say it's unlikely, which will guarantee that it'll happen. Whalier says the slur the lawyer used was Latinx. Jennifer Genter says, "Nick, we need to stop the case and help uncivil." Agent Rude says the prosecutor may sound aggressive because he spent all day dealing with bullshit motions from the defense. Stephen Oglesby says, "Handbrake." Kevin Speaks on It says, "Hannah bro tonight, Nick?" Probably. We might do his police interview. We got to figure out or finish up the lesbian lovers testimony as well.
I missed that.
Yeah, that's in the
poor judgment.
that's in the chopping up of the parents' case. I need to tell you this story, and I can't do it now because I've got to finish up, but I need to tell you this story sometime about that case because it seems so straightforward. And then as the case is going on, it's like, this has every hallmark of being like a movie that is ridiculous, but I don't think it actually is. It just, everywhere there's like, this could be a true crime story. This could be the greatest story ever told of deceit and of manipulation and of murder by proxy and all of this stuff. But I think it's actually just a guy chopped up his parents and probably ate part of them. Carter says, "No question. Just wanted to say some thanks for all of the panel for putting out the content across the channels. Learned a lot and enjoy every step. Take a shot for me sometime and happy 2022, y'all." I can't take any more shots today because I only had the one drink and I have to go drive in a little bit. Al Fiver says, "Off topic, but I want to know now that Biden has officially endorsed it, what do you think the chances of the filibuster being changed and done away with is?" Low. I think it's still low, and it would be, if they do it, they're opening the floodgates. It'll be because I think the Democrats are aware that they stand to lose the House and possibly the Senate at midterms. If they do that after destroying the filibuster, they're going to have a very, very bad time, especially if there's a Republican president in 2024. So
yeah, just imagine what President DeSantis will do without a filibuster to stop him.
Yeah, without a filibuster and very possibly with a Republican House and Senate. All the Democrats in the Senate are thinking about that as a nightmare. It's a much better sounding point for political points than it is for actually getting it done, in my opinion. Bradley Denton says, "Hey, Nick, my childhood best friend was murdered 3 years ago and thrown in a ditch. His killer was charged yesterday. Can I get a cheers for justice?" I can't, again, I unfortunately cannot give liquor to that very good news because I have to drive in just a minute, but with a cherry Coke, cheers. May your friend who was murdered find peace. May their family find peace and justice, hopefully in a court system that will be untainted by politic, untainted by outside influences, and will find the truth and the facts and get to a resolution. Cheers, man. That's good news on a really heavy topic. Jonathan Duger says, didn't the car hop the curb? I don't know if it did. It's hard to see on the video. It could have. Palms Freets says, the victim's wife was driving the Kia, so wouldn't she be the nearest, most obvious witness? Yes. And she'll be called by the state. Absolutely. She's going to be the highest one on the list. Bradley Denton says, his name was Timothy. He was killed and thrown in a ditch. We grew up together, and 3 years was far too long. Just a relief to see someone charged. And then James Spoon says, the Cinemax version of the Canterbury's trial will need some major recasting. Oh, yeah. Yeah. This is, whew. These are not Showtime lesbians. Okay. With that, I'm done with Super Chats. I've got to go. Thanks for joining me tonight, man. That was awesome.
Thanks for the invite, Nick. I appreciate it as always.
Yeah. And just let me know if you want me to pop on the show. I'm happy to do so. So
in the near term, I do want to follow up with you with that, whatever that weird spreadsheet thing is that you have for the Super Chats. That would be very helpful, but I'll contact you offline about that.
Absolutely. All right. To the chat. Thanks for joining us today. We'll catch you guys. We'll catch you guys soon. I'll be broadcasting tonight at 11 p.m. Central, and I'll hopefully see you there. Have a good night, guys. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side, if his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitter and Erland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed, make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more of that rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Dante to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nam to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for